call the August 27th, 2021 meeting of the Energy Facility Siting Council to order. Mr. Secretary, please call the roll.
Marcy Grail.
Here.
Kent Howe.
Here.
Hanley Jenkins.
I'm here, but my video isn't working.
Jordan Truitt.
Here.
Cindy Condon.
Here.
And
Here.
Perry Choctoot. I got you. Thank you, Cindy. And Perry Choctoot. Yet. Okay. Madam Chair, you have a quorum.
Thank you. Mr. Secretary, are there any agenda modifications?
Madam Chair, there are no agenda modifications at this time.
Thank you. I have the following announcements. Please mute your phones, and if you're joining us by phone and receive a phone call, please hang up from this call and dial back in after finishing your other call. For those signed onto the webinar, please do not broadcast your webcam. For agenda item C, public comment period, there are two ways to let us know you are interested in providing comments to the council. For those using the WebEx, you will need to use the raise your hand feature. For those on the phone only, you will need to press *3, which will alert us that you want to speak. We will go over these options again during that agenda item. If you want to receive future email notifications of council meetings, project milestones, or rulemakings through our Click Dimensions program, you can do so by clicking on the link in the agenda or on the council webpage. Look for the green box on the right-hand side of the page that says sign up for emails updates. You are also welcome to access the online project mapping tool in any documents by visiting our website. Energy Facility Siting Council meetings shall be conducted in a respectful and courteous manner where everyone is allowed to state their positions at the appropriate times, consistent with council rules and procedures. Willful, accusatory, offensive, insulting, threatening, insolent, or slanderous comments which disrupt the council meeting are not acceptable. Pursuant to Oregon Administrative Rule 345-011-0080, any person who engages in unacceptable conduct which disrupts the meeting may be expelled. So moving on to the approval of minutes, is there a motion to approve the minutes from the July 23rd, 2021 meeting?
Madam Chair, this is Hanley Jenkins, and I move that the council approve the minutes of the July 23, 2021 meeting as presented.
Thank you, Hanley.
I'll second that. This is Kent.
Thank you, Kent. Is there any discussion? I will remind everyone that I'm using my phone, so I probably won't see you if you raise your hand. Todd's going to be on the lookout, but if you speak up, I won't be offended if you speak without being called on. So if you have any comments, please do so.
Madam Chair, I see Councilmember Condon has her hand up.
Thanks, Todd. Cindy?
Yes, thank you. In the minutes, sorry, I'm using two computers. In the minutes, there's a comment of mine where about where we rely on staff for information, that in the order of review of our standards. And I wanted to be clear about that. Obviously, we rely on staff for a lot for all of the standards. It was outside of, where we have other agencies involved in the review, like Fish and Wildlife, and it was the standards like the financial responsibility and the organizational expertise, where it's not another agency, it's us determining that. And I just wanted to make that clear. I know we rely on staff for information on every standard. And so it just was not clear in the minutes that that's what I was after. Does that make sense?
Councilmember Condon, are you interested in making any changes to that?
Yes, it would be, sorry, I'm just trying to find it. It's
I think it's on page 9.
sorry, where it says, council member Condon expressed preference for standards where the council is relying on staff to provide the necessary information that, staff, ODOE staff, rather than outside, agencies like Fish and Wildlife and whatnot. That was my preference.
Okay, so, sorry, I'm trying to find the location so I can.
Sorry, it is right before the 2021 legislative session FSEC related bills in the minutes. It's sorry, I don't have a page number on my.
Looks like it's page 3.
Okay, so the sentence is Councilmember Condon expressed preference for standards where the council is relying on staff to provide the necessary information. Is that the?
Yes,
location? And you're wanting to change it to?
staff only, ODOE staff. What I'm concerned about is, well, sorry, I didn't give thought to how I'd like it worded. It's the standards that rely on ODOE staff and council only to make a decision. For instance, the corporate, the organizational expertise. To my knowledge, we're not going to, for instance, the corporations division or another division to do an analysis to say, yes, this is a company that has the organizational expertise. I realize that staff, ODOE staff, does it with respect to projects, but the depth of the financial stability or experience of the organization.
Excuse me, this is Hanley, and this may be my fault because I asked Donette to take the word council out before the word staff. So it would read, Councilmember Condon expressed preference for standards where the council is relying on council staff to provide the necessary information. Would that make it more clear? So then it's our staff.
Yes, I think that would do it.
That or the Department of Energy staff, either one.
Yeah, either.
I'll
Maybe it's that I don't.
put Department of Energy staff.
Yeah, let's do Department of Energy because the council is what confused me.
Yeah. That seems a little clear in mind. So yeah, I've made that change to add. So the sentence would now read, Councilmember Condon expressed preference for standards where the council is relying on Department of Energy staff to provide the necessary information.
Right. Yeah. Yeah, I'd agree to that. Kent?
Does that work for you, Cindy?
Yes, thank you.
Kent's the one that
Okay,
seconded.
so Hanley, you initially made the motion and now we've got a correction, a friendly amendment. I don't know what we're going to call it, but
Sure. Friendly
we-
amendment, great.
This is Kent, and I will
Oh.
second the friendly amendment.
all
And I had
right.
made note of
awesome.
that for in the motion as well as in the draft minutes as well. So I think it's pretty clear in terms of the record. So I don't have any concerns about that.
Okay.
Thank you, Todd. All right, any further comments or questions on the minutes? Hearing none, Mr. Secretary, please call the roll.
Kent Howell,
Yes.
Hanley Jenkins,
Yes.
Jordan Truitt,
I would like to vote yes, but I was not present. Should I abstain from my vote?
yeah, I think that's appropriate.
I will abstain from voting.
Perry
Thanks,
Chalktoot,
Jordan.
Yep.
I think Councilmember Chalktoot is with us now. Is that correct, Anita?
That is correct. Councilmember Choctoot was on mute. He should be good now.
Okay, yeah, just call,
Also have to abstain on that, Mr. Cornett.
oh, that's right. Got it. Cindy Conan,
Yes.
Marcy Grail,
Yes,
motion carries, Madam Chair.
thank you. The next agenda item relates to the Boardman to Hemingway transmission line. Since I've previously recused myself on all Boardman to Hemingway action items, I'm similarly going to recuse myself on agenda items B and C and turn over the running of those items to Vice Chair Howe. Vice Chair Howe, if you will please pick up, I would appreciate it.
We have-
Madam Chair, if I may, just one secretary report.
Oh, gosh, sorry. Jumped right over you, Todd, right
That's
over.
okay.
My apologies.
And it is your prerogative. You don't want a secretary report today. That is okay by me as well.
No, we want to hear from you. I just skipped over you looking at my bright red note. Sorry.
No problem. First is council updates. So the next legislative days are scheduled for September 22nd, 23rd, and 24th. That means that there could be possible replacements for council members Jenkins and Winters. However, at this point, I have not received any definitive updates about whether names are being put forward by the governor to the Senate Rules Committee. So it could be that both Councilmember Jenkins and Councilmember Winters are replaced. It could be that one of them is replaced. It could be that neither one of them is replaced. And so we're just kind of on hold, waiting to find out from where that's at. And I know Councilmember Jenkins has indicated that he would be unavailable for the September council meeting anyway, unless we need a quorum. But at this point, we've heard from all other council members outside of Councilmember Winters. And so we do have 5 indicated availability for September, so we should be fine regardless of what happens. So next, I'll get into some project updates. The first is on the Boardman to Hemingway transmission line. So as part of the council packet, 2 weeks ago in the initial council packet, we provided you with the contested case update from the hearing officer. So unless you have any questions about that, I will just let the update from the hearing officer stand and move on to the next project update. Okay, seeing no questions. The Boardman Solar Energy Facility Amendment Determination Request, that's the next one on my list. So this project is an approved 75 megawatt solar PV facility on approximately 798 acres, so 1.25 square miles. It's located in northwestern Morrow County. The site certificate holder is currently seeking their first amendment, which would extend the beginning and construction deadlines by 3 years. The amendment request itself does not include any substantive changes, just changes to the beginning and ending construction deadlines. As part of their amendment, they did request Type B review. On August 12th, the department determined that Type B was justified for this review. The justification for that was based on an evaluation of any changes of factor law that occurred between the time the council originally approved the facility and now. Determined that there was not any substantive changes in factor law, and there was minimal interest by the public, and all of the issues that were raised by reviewing agencies were addressed. So based upon that assessment, overall, I can get into the specifics if anybody has questions. We, the department, determined that Type B was justified and made that determination. And that determination was sent to council on the same date, August 12th as well. So as just a reminder, the way that process works is once the staff makes the determination, only the applicant under a Type B can raise the review of that to council. So that one holds unless the applicant or the certificate holder themselves wants to raise that to council. Next on my list is the Bonanza Energy Facility. This is a proposed 150 to 300 megawatt solar PV project with up to 1,100 megawatts of battery storage. The facility would be located on 2,700 acres, so 4.2 square miles, located just outside the town of Bonanza in Klamath County. The project is still at the notice of intent stage, and so we anticipate receiving a preliminary application for site certificate later this year. But again, important to note, we do not have a application as of yet. There was a meeting by members of the public in the vicinity of the project last Wednesday. We alerted you to that meeting in case any council members wanted to attend that meeting. And so we provided that information to you. Just as a kind of an overall, we've continued to get comments received from members of the public about this project. We're not in a public comment timeframe. There are specific public comment timeframes in our process. Nonetheless, people continue to express interest and concern about this project. Many of them have asked for those comments to be passed on to the council. We have continued to pass on those comments to council as they come in. And the last one that we received was from Elizabeth Hubbard, if I'm pronouncing her name correctly. And that was included in your round 2 packet, so last Friday for this meeting. So just want to make sure that was on the record for both council and anybody who is interested in that project who might be listening today. Next are wildlife monitoring and mitigation updates. And these are specific to the Leaning Juniper Wind 2A and Leaning Juniper Wind 2B projects. In June of this year, you were provided with wildlife monitoring and mitigation plan updates for several wind facilities based on annual reports that were submitted to the department. At that time, Avangrid Renewables, the certificate holder for both the Leaning Juniper projects, reported that no 2020 surveys or monitoring per the plan requirements was conducted due to COVID-19. These projects are located in Gillum County, just so you know. Even though those surveys were not done in 2020, they were rescheduled for 2021 and were completed in the spring. And the certificate holder submitted the reports and findings of the Washington ground squirrel and raptor nest surveys conducted in April and May of this year, and there were no significant findings or changes reported in those inventories. So even though COVID kind of put some limitations on what they could do, they did follow up, they did do the surveys and found no substantive changes or significant issues. So these reports and findings have been reviewed by the department, and we have uploaded them to the specific web pages for the projects, and they are open for public comment until October 20th of this year in case anybody wants to provide public comment. Next is the Bigelow Canyon Wind Farm. This is a 450 megawatt wind facility consisting of 217 turbines located in Sherman County. On August 19th, we received notice from Portland General Electric, who is the certificate holder, that a hawk hit an overhead line. That hitting the line caused a spark, which started a fire that grew to approximately 26 acres and ended up burning a dilapidated house and old farm equipment before it was put out. So as with all site certificates, the certificate holders have a 72-hour notification requirement to the department on incidents like these. So Portland General Electric met that condition, provided us that information, the basic information, within 72 hours. And they're continuing to look at the issue. And so that's really all of the information that I have at this point in time, but we will continue to look further into it and make sure that there are no violations of conditions of approval. And we understand sort of the reasoning behind that. So that's still sort of to be determined with some more information. Before I move to the last update, I just want to make sure that there were no questions on that incident. Okay, seeing none. Last on my list is the Golden Hills Wind Project. This is a 200 megawatt wind energy facility in Sherman County that has just recently begun construction. We recently, earlier this week, received an inspection request from adjacent farmers. So we have a process by which if somebody believes that there are violations of conditions of approval, they can request an inspection by us to make that verification of whether or not there are violations of conditions. And so the adjacent farming operators have expressed concerns that the construction is occurring in violation of several site conditions, site certificate conditions related to fugitive dust, topsoil management, the size of the disturbance areas for each of the turbines, and some of the facility layouts, which in fact will impact long-term agricultural operations. So Avangrid Renewables, who is the certificate holder, is aware of these concerns. They have submitted a response already to us. We are currently evaluating both the concerns that were expressed as well as Avangrid's response. And Dwayne Kilzonk, our compliance officer, is likely to conduct a site visit early next week. So at this point, we're just gathering information. We're just evaluating it. We have no idea if there is truly a violation of conditions of approval or not. Again, just in the fact-finding sort of stage of making that determination. So I'll follow up with council next month on what we find related to these concerns that were expressed to us. And last on my list, I already talked about this a little bit, is the September council meeting. That is, the dates are scheduled for September 23rd and 24th. We do need a council meeting. We only need a one-day council meeting, so only on the 24th. And because of the increase in the Delta variant with COVID, we will likely continue to have virtual meetings for the near future. So just probably being on the safe side, that makes the most sense. And I had indicated that Councilmember Jenkins and Councilmember Winters would not likely be available. So the remaining 5 council members had all expressed their availability. So I just wanted to check in to make sure that there are no changes to anybody's availability on the 24th. Probably a shorter meeting, but just to make sure, because we still need all 5 other council members in order to have a quorum, I wanted to make sure there were no changes in people's schedules. Okay, silence works for me, and so I will take that as that we have availability. Madam Chair, that concludes my secretary report. Unless there are any questions for me, I will turn it back over to you.
Thank you. Any questions for Todd? I don't see any questions for you.
Yep, I don't, yeah, and I'm looking as well,
Okay.
and I do not see any, so thank you.
Great, thanks. So as I previously stated, the next agenda item is related to the Boardman to Hemingway transmission line. Since I've previously recused myself on all Boardman to Hemingway action items, I'm similarly going to recuse myself on agenda items B and C and turn over the running of those items to Vice Chair Howell. Vice Chair Howell, thank you for being willing to do this, and I will turn it over to you at this time.
Okay, thank you, Chair Grail. And as Chair Grail said earlier, if somebody is wanting to speak and I am unaware of it, please interrupt and let me know so I can recognize you. So what we have here for item B is a motion to remove the Boardman to Hemingway contested case hearing officer, Jesse Ratcliffe, Oregon Department of Justice Senior Assistant Attorney General, will provide an overview of the request by Mrs. Irene Gilbert to remove Oregon Office of Administrative Hearings Senior Administrative Law Judge Allison Green Webster as the FSEC appointed hearing officer for the Boardman to Hemingway contested case. There's been a request for oral testimony by Ms. Gilbert and Idaho Power at the end, and we will allow that for a limited time, and we can discuss the time then. So at this point, Mr. Ratcliffe, the floor is yours.
Thank you, Vice Chair Howe and members of the council. So my suggestion is that I'll go ahead and provide a very brief sort of introduction to the topic, and that we have oral argument following that. And then once that's done and we've heard essentially everything that that Ms. Gilbert and Idaho Power have to say, both in writing and orally, at that point, I can jump back in and talk some more about the standards, legal standards governing the bias and incompetence grounds for requesting removal, and talk a little bit about how those standards apply to the issues that Ms. Gilbert's raised. So with that, I guess I'd suggest that we go ahead and have the oral argument part of this.
Okay. So do you want me to jump in and do we have Ms. Gilbert?
So excuse me, this is Hanley. Did you want to
Yeah.
talk about limiting the time period for these
Oh.
presentations?
Correct. Yes, that's a good point. Thank you. Yeah, so I'm thinking 2 or 3 minutes per on this. What's the rest? First, the pleasure of the council as far as oral testimony from Ms. Gilbert and Idaho Power.
Oh, this is Hanley. I think 3 minutes.
Yeah, this is Jordan. I agree. I think 3 minutes is good.
This is Perry. I agree also.
I'll go with that.
Okay, it sounds like we've got a time limit then of 3 minutes. And do we have Ms. Gilbert online ready to go?
Irene Gilbert is unmuted and ready to go.
Okay, Ms. Gilbert, you can start your oral testimony for 3 minutes. Is anyone hearing her? This is Kent. I'm not hearing anything. Ms. Gilbert, if you can hear me, we cannot hear you.
It would look like she's having audio troubles.
Maybe we should reverse the order while Ms. Gilbert tries to get dialed in. So I think she
Yes.
uses a phone.
Yeah, that's a good idea. Is Idaho Power on the line?
I have Jocelyn Pease.
Yeah, Donita. So yeah, Lisa Rackner and Jocelyn Pease, please unmute both of them. And then they can indicate if there's anybody else from representing Idaho Power who would like to participate.
Okay, Jody Pease and Lisa Rackner are both unmuted.
Thank you, council members. This is Lisa Rackner for Idaho Power. We provided a response to the motion to remove the hearings officer in this case, arguing that there was no basis for the motion. We don't really have anything to add to what we said in our motion, although we would like an opportunity briefly to respond in the event that Ms. Gilbert, if we are able to get her online, makes her argument and adds anything beyond what she put in her pleadings that we feel it's necessary to respond to.
That sounds fine to me. Is that okay with the rest of the council? Okay, I'm seeing thumbs up and all good. So let's go back then to Ms. Gilbert and see if she's able to speak?
I have her unmuted, but it may be prudent to maybe give her the option to telephone in.
Yeah, why
She's-
don't we try that? If, Ms. Gilbert, if you can hear us, why don't you try telephoning in? Donita, can you give her the phone number to call?
Yes, I'm pulling that up as we speak. The telephone number that you can use is 415-655-0001. Access code 145-788-3683.
Why don't you repeat that, Donita?
Sure, that is again 415-655-0001 with access code 145-788-3683.
Donita, this is Sarah Esterson. I'm going to send that information to her via email as well.
Okay. And then Sarah, in the email, I'm going to let her know verbally how to unmute herself via the phone. But you may want to let her know in that email that *6 is to unmute. *3 is to raise your hand by phone.
Okay, got it.
So again, Miss Gilbert, that's *6 to unmute and *3 to raise your hand by telephone.
Donita, this is Hanley. Do we even know that she's connected or tried to connect?
I can see that she is in the group of attendees,
Okay.
and it gives me the option to unmute or mute her right now. She is unmuted. Sarah is emailing her just in case for some reason she's not able to pick up everything that we're saying.
So this is Hanley. Jesse is, can we move forward and come back? Is that an option here?
Yes, Councilmember Jenkins, I think we can go ahead and do that. And I guess what I'd just say is if Ms. Gilbert has the opportunity to get online here, then she can go ahead and go after. If there's anything that we hear in a subsequent presentation from either Ms. Gilbert or Idaho Power that the council feels that they would like me to address, then I can weigh in on that specifically, but I think I can just start in.
Yeah, so Kent, this is Hanley. I think we want to reserve the right for Idaho Power to rebut or respond as well, if Irene is able to get access.
That makes sense, and I think it's appropriate. We've given a long time here to go ahead and move to the McAllister item, and we'll come back to this and see if Irene can get on to speak to us or not, and then allow Idaho Power an ability to respond to that. Okay, so with that, I think I'll go ahead.
So, Mr. Vice Chair, just for clarification, Jesse, you can chime in. My understanding was that you were probably going to do your presentation on the agenda item B. Was that correct? Or were you thinking that we would move on to agenda item C?
Yes, thank you, Secretary Cornett. So I guess I had been thinking that I could do my presentation on Ms. Gilbert's motion. However, moving on to Mr. McAllister's interlocutory appeal is also fine if that's the will of the council. My understanding is that we do not have any requests for oral argument on the McAllister motion. So, you know, I don't know that shifting the order around is going to be problematic from that perspective, at least. So I'll turn things back over to the council and see what they would like to do. But there we are.
Yeah,
Okay.
this is Hanley, Kent. I'd like to continue with this.
Okay.
And if Ms. Gilbert's able to dial in or present her arguments, then we'll do that while we're in this agenda item. Otherwise, I think we need to complete this and move on to the next agenda.
Yeah. Okay. So, Mr. Ratcliffe, the floor is yours to continue on with item B.
Sure. Thank you. So again, Ms. Gilbert's motion here is a request to remove the hearing officer on two grounds, bias and incompetence. Ms. Gilbert's motion alleges a number of actions that she says the hearing officer has taken that would constitute one or the other or both. And so what I'm going to do for you here is talk a little bit about the legal standards governing a bias or incompetence finding, and then get into the specific issues that Ms. Gilbert has raised and provide advice pertaining to each one of those allegations. So one formality.
Sorry, Jesse, sorry to interrupt. I just got word from Donita that Ms. Gilbert has been able to join by phone. So Donita, can you confirm that that Ms. Gilbert is available and is ready to go? So sorry to interrupt, but so I don't know if you want to go back to her or continue on yours, but I just want to make sure that you're all aware of that.
Let's go back.
If she's available, let's go ahead and do it. That'll help maybe for an understanding of Mr. Ratcliffe's comments and how it relates to what she said. So let's go ahead and if she's on, let's hear what she has to say.
Ms. Gilbert, are you able to hear?
Can you hear me?
Yes.
Very good.
Okay, 3 minutes, wow. So thank you for hearing from me. The issue here is that the rules say that a hearings officer must take all necessary action to ensure a full, fair, and impartial hearing and facilitate presentation of evidence. I believe my written comments document the fact that whenever Ms. Webster had an opportunity to make a decision that denied the public a full, fair, and impartial hearing and the opportunity to present evidence, she chose to make decisions that disadvantaged the public. Some of those actions are listed in my request that she be removed, and they include things like allowing the Oregon Department of Energy to define the contested case issues, giving the public 7 days, including a holiday, to respond in terms of when those listings of issues were either defined, redefined, misstated, or left out of the order that she gave, and requiring all petitioners to use the ODOE flash drive for all files and exhibits and referencing them in the way that ODOE does rather than standard methods of identifying exhibits. Ms. Webster has a track record that simply cannot continue to be ignored. Some of her summary determination requests sort of pushed the envelope over the cliff, if you will. She received 33 requests for summary determinations on contested cases the public was pursuing. She decided against the public in all 33 issues and threw out cases without a hearing, including 4 of the 6 issues the council added to the contested case listing. Ms. Webster's report to the council lists the case codes, but it doesn't indicate what these issues were. Some were whether the developer should have to include Morgan Lake Road in the site boundary due to substantial modifications needed and provide notice to adjacent landowners, whether the applicant adequately analyzed sage-grouse habitat connectivity in Baker and Cow Valley priority areas of conservation. Ms. Webster removed the requirement to include state-sensitive bat species in pre-construction surveys.
One minute remaining.
Okay, in pre-construction surveys, as well as the requirement that the developer notify ODOE and ODFW when they identified pygmy rat colonies or rat roost or hibernatia in their during their construction. One of the issues that I had problems with is she decided to use the Oregon, the Union County zoning and petitioning rules rather than the state statutes when determining what was forest land. Now, this has serious concerns and causes serious consequences. Landowners are required to be given the value of the timber that could be produced over 100 years of the project if it's forest land. That amounts to $21.3 million per ODOE calculations. So if you're shorting the amount of forest land, you're cheating landowners out of those payments.
Ms.
The
Gilbert,
developer is not required. Yeah. Okay. Can you just do my final statement? Anyway, it's simply wrong for Ms. Webster to place the public in a position of having to pay for an appeal to allow a developer to void their responsibility to meet Oregon law. When she decides to use local rules over state statutes to decide what land is forest land, she is undermining the entire land use laws of this state. And those kinds of decisions just can't continue to be made. And this is just one example.
Okay, thank you, Ms. Gilbert, for your oral testimony. Idaho Power, Ms. Reckner or Jocelyn, which one or both did you want to respond?
This is Lisa. And again, I think we just rest on our comments in our response and would point out that while Ms. Gilbert has listed a number of rulings that the hearings officer has made with which she disagrees, she hasn't provided any legal argument as to why those decisions were wrong or how they show bias. And with that, I think we would conclude.
Okay, well, thank you. And so, Mr. Ratcliffe, we turn it back over to you.
Sure, thank you. So again, where I'm going to head with this is to provide the council, first of all, the rule on which Ms. Gilbert bases her motion, the legal standards at issue here, bias and incompetence, and to provide a little bit more detail about the reasons that Ms. Gilbert has asserted, demonstrate either bias or incompetence or both, and provide the council with some advice pertaining to those assertions. So one formality here before we get into the substance of that. So what I have provided the council with written legal advice in the advance of the meeting. My presentation is going to be based off of that advice. Advice that I present to you is attorney-client privileged. When we talk about it in open session, it is likely that some part or all of that written advice, the privilege could be waived. I can't waive the privilege myself. Only the client, in this case, the counsel, can do that. And so my understanding is that generally the council prefers to do these things in open session rather than executive session. And with that understanding, I'm just going to pause here for a moment and see if any of the council members object to me going forward with the knowledge that some part or all of the written confidential advice, that privilege could be waived.
So Jesse, this Kent, this is Hanley, and Jesse, do we need a motion to waive that attorney-client privilege at this point?
No, I don't think so under the circumstances.
Okay.
Councilmember Jenkins, I think if we don't have any objections, I can just take that as consent.
Yeah, I would support moving forward with the discussion on this.
This is Kent, and I do as well.
Cindy's thumbs up. Jordan?
Yep, I consent.
Okay. Harry, I can't see you.
I agree. We need to move forward.
Okay, great.
Okay, thank you for that. So the legal standard, the rule that Ms. Gilbert bases her motion on is OAR 345, Division 23, Rule 23, Sub 7, which provides that the council, either on its own motion or on the motion of a party or limited party, can remove a hearing officer if the council determines that the hearing officer is not competent to conduct the proceeding, is demonstrably biased for or against any party, or is otherwise unable to conduct the proceeding. And again, Ms. Gilbert's motion here is based on bias and incompetence. One thing that I'd like to note before going into those legal standards is that there are other forums, either administrative law forums in the state or courts, where there is a lower bar for removal. So there are some instances where you can request for good cause, for example, whatever that good cause might be in the eyes of the forum. Here, however, the council has permissibly chosen a standard that requires specific showings. And in order for the council to make a decision to remove the hearing officer, the moving party, Ms. Gilbert, has to demonstrate that one of the grounds for removal has been met. So starting with bias, the council's rules don't define bias, but this is something that has been considered with relative frequency by organs courts. And so in the advice I provided, I provide some of the case law there that talks about what does and does not constitute bias. The basic test is that it requires substantial evidence of actual prejudice. It requires more than simply the appearance of unfairness. So some examples of bias include if you have some kind of animus toward or prejudice concerning one or more of the parties, if you make a decision in the proceeding prior to considering the facts, or if you have personal contacts with parties or knowledge of the facts in other than your capacity as a hearing officer, that's limited to only where the contacts or knowledge would create an objective likelihood of prejudice or animus. In contrast, and importantly, the fact that an administrator or a hearing officer holds a generalized view of questions of law and policy is insufficient to establish bias. Reasoned differences of opinion and even outright errors by a decision maker are not bias. And this is important because you frequently have judges, hearing officers who have their interpretation of the law, and that on its own isn't an issue of bias. It's an issue of kind of holding a reasoned view. Now a court of appeals or some other appellate forum, they may disagree. But that doesn't mean that the judge, the hearing officer who initially made the decision is biased. It just means that they have looked at the law, come to a conclusion that they believe is supported. So that there is an important distinction there. So that is the bias standard. I will pause here for just a second and see if there are any questions about that. If not, then I'll talk a little bit about the incompetence standard and then get into Ms. Gilbert's specific assertions.
Any question from counselors? Okay, it looks like you can proceed, Mr. Ratcliffe.
Thank you. So again, with incompetence, there's no definition in the council standards. There's also comparatively little Oregon case law addressing a hearing officer or agency decision maker's competence or lack thereof. And so in that circumstance, a typical approach to interpreting statutes and rules in Oregon is to look simply at the plain text definition of the word or phrase. So a dictionary definition of incompetent is lacking the qualities needed for effective action, or being inadequate or unsuitable for a particular purpose. And with that in mind, a hearing officer is required to fulfill specific duties over the course of a contested case hearing. The council's rules helpfully spell out these rules, these duties in detail. Those can be found at OAR 345 15-23. Some of these things are pretty straightforward, like maintaining the record of the proceeding, administering oaths and affirmations, and that kind of thing. But some are going to be open to interpretation and are going to require the hearing officer to exercise discretion. One of those being the requirement to ensure a full, fair, and impartial hearing. So if we're in a situation where we have an unexcused failure to fulfill these duties, or clear and repeated abuses of the hearing officer's discretion in fulfilling them, that might be a situation where a hearing officer is deemed unsuitable for the role. The council has had an instance in the past where a hearing officer was removed after kind of clear and repeated demonstrations of an inability to perform the basic duties of a hearing officer. But in contrast, if the hearing officer is making reasoned decisions in complex areas of law, the question of whether or not the hearing officer is ultimately right or wrong about those decisions, generally speaking, that is not going to be sufficient to establish incompetence. It's very common for lower courts and administrative bodies to be overturned. Usually you end up in a dispute before an administrative agency precisely because things are complex. They're not simple to figure out. So in general, there's a fairly wide bar for latitude to make those decisions, knowing that there's an opportunity for review of them by a higher tribunal. So again, I'll pause briefly there, see if there are any questions about the competence standard, and then I'll get into the specific assertions that Ms. Gilbert has made.
Any questions or comments from the council on the incompetence standard? Okay, you can proceed, Mr. Ratcliffe.
Right. Okay, sorry, my screen is not cooperating here for a second. All right. Ms. Gilbert has listed in her motion about 10 different either individual actions or categories of actions that she believes demonstrate either bias or incompetence or both. I have looked at those sometimes in groupings of actions if I think there's kind of a broader category of assertions here at play. So the first kind of set of actions that she refers to are related to the party status and contested case issue determinations. And so most of the council members were on the council here when the council heard appeals by individual parties of some of the hearing officers' party status and contested case issue decisions. So again, that's an earlier stage in the process where after contested case requests are made, the hearing officer is supposed to apply the law that pertains to when a party is properly designated a party or limited party, and to determine what issues they have properly raised on the record of the DPO. So, the bottom line here is that there were a number of parties who disagreed with the hearing officer's rulings along the way in making those determinations. There was an opportunity for appeal to the council concerning those issues. The council reviewed all of those appeals. Ultimately, the council upheld most of the hearing officer's decisions, but not all of them. But I think the bottom line, and for the council members who were present, there was extensive discussion in cases where the hearing officer was overruled by the council. In my view, these were not simple issues. They required that extensive discussion. And the fact that the council came to the conclusion on a number of parties or issues that the council believed overruling the hearing officer was appropriate, I don't believe that demonstrates any lack of competence or bias. It appears to be the case rather that the hearing officer took a reasoned look at everything, made her decisions based on her understanding, generalized view of the law, and reached the conclusions that she did. So with respect to that kind of grouping of actions, that's my recommendation there, is that in some sense the council has already looked at these things, reached its decisions, but was not of the mind that the hearing officer's conduct was egregious in any particular way, just simply that the council disagreed in a few instances. So that's yeah, go ahead.
Just before you move on, this is Hanley. We heard 2 days of testimony on those issues and deliberated very extensively on those. And I think your assessment is very accurate, that it was, on the council's part, was additional evaluation and of those issues that resulted in changes. It wasn't a result of any error or failure of obligation or bias on the part of the hearings officer. So I wanted to add, we heard a lot of testimony associated with those issues for 2 solid days. And I think it's pretty clear that the council came to a different decision. That's all that it amounted to. Thank you.
So then the next action that Ms. Gilbert raises is the allowance of a particular kind of motion in the contested case proceeding. That motion is called a request for clarification, and it's essentially just what it sounds like. It's a motion that a party makes when they're uncertain about the scope or meaning of a particular ruling by the hearing officer. Ms. Gilbert's concern here is that the Department of Energy has made more than one of these requests for clarification, and Ms. Gilbert's contention is essentially that this is kind of a second bite at the apple, that the hearing officer has allowed these kinds of motions, and so is in some sense giving extra deference to the Department of Energy. I've taken a look at this one as well, and the advice I have on this is that the council's rules, they provide a general rule for the making of motions in a contested case proceeding. They don't spell out all of the different kinds of motions that a party is entitled to make or may not make. And so in that sense, the hearing officer has some discretion in trying to decide what motions to consider, you know, and perhaps what kinds of forms of motion that she feels are just sort of out of bounds in the proceeding. A request for a clarification motion is something that is extraordinarily common in legal proceedings. You know, although we impose all sorts of formalities that are intended for the protection of the parties on legal proceedings, at base, it's a conversation between the parties in interest and the decision maker. And if you have kind of a one-sided conversation coming from the hearing officer or the judge with no opportunity for feedback, you can end up in a situation where there's unnecessary confusion about what a ruling means. And that can have effects that kind of, you know, feed into the rest of the case and can result in inefficiencies, you know, that perhaps may need to be addressed by a reviewing court, which they would much prefer not to do. So in my view, this is a pretty routine kind of motion that any of the parties to this proceeding could avail themselves of if they are concerned about, you know, their understanding of what the hearing officer has decided. You know, in this case, I don't, you know, I don't see any evidence of bias or incompetence here. And in fact, this is what I would expect from the hearing officer, is to permit those sorts of motions. And if she believes that there is something that truly is unclear, to respond to that. Before I go on to the next action, I would note also that under the same heading about the request for clarification, Ms. Gilbert has also asserted that the hearing officer should have limited Mr. Rowe's participation in the Boardman to Hemingway contested case. To be clear, Mr. Rowe is an official of the Department of Justice, and his statutorily defined role is to represent the state of Oregon. In the current proceeding, Odo and the council have requested to have separate attorneys for Odo and the council. Mr. Rowe is representing the Department of Energy staff. I'm representing the council. There's no legal obligation to have that separation. In most of the proceedings that I am involved in contested cases, I advise the department staff and the ultimate decision maker, whether that's an agency director or a board or commission, and that's the law in Oregon. But the Department of Justice does consider agencies' requests in deciding whether or not to separate functions, and in this proceeding has agreed to do so, and has in the past as well in other FSEC contested case proceedings. The Department of Justice itself is not a party to this proceeding. Mr. Rowe and I are both officials with the Department of Justice, but ultimately, again, we represent the state of Oregon. So Ms. Gilbert's contention here is essentially that, that the hearing officer should have taken some action with respect to Mr. Rowe, but there was simply nothing for her to do. Mr. Rowe's participation in the case is appropriate, and there's absolutely no grounds for removal or limitation. I'll pause again if there are any questions on this, and then go into the next assertion that Ms. Gilbert makes. Okay. So the next assertion has to do with the hearing officer's rulings on motions to compel discovery. Discovery is a tool that's used in contested case proceedings by the parties to, make requests of the other parties to provide information that either they may be submitting as part of their case or that might be relevant to the case, even if they're not planning on submitting it. Ms. Gilbert asserts that the hearing officer considered and denied motions from some of the limited parties that were attempting to compel discovery from either Idaho Power or the department. The parties' motions to compel are a routine and appropriate part of the proceeding. If you're not satisfied with the responses you get making an informal discovery request, you can ask the hearing officer to weigh in and consider whether or not the requests were incomplete. In this instance, the only evidence that Ms. Gilbert has provided in support of her assertion is the hearing officer's simple denial of those motions. Without more on this issue, the fact that she's ruled in favor of Odo or Idaho Power on the motions isn't in itself evidence of either bias or incompetence. Each one of these motions is going to be highly fact dependent. To demonstrate some kind of bias or incompetence, there really would need to be a pretty detailed analysis of those decisions, and that's lacking here. The next actions are I've grouped into case management issues. Ms. Gilbert's asserting that the hearing officers made certain decisions along the way pertaining to the management of the case that are burdensome to Ms. Gilbert and the other limited parties. Examples of those that she's provided, including the hearing officer's decision to require everyone in the case to refer to a specific compiled version of the record, and another decision being requiring notarized affidavits from parties instead of allowing the use of the somewhat less formal declaration by a party. On this issue, one thing that I'll say about this in general is that there's absolutely no doubt that participating in a case like this with so many issues, such a large record, it's very challenging. It's challenging for parties represented by an attorney, certainly challenging for parties not represented by attorneys. So I, as someone who, participates in these sorts of hearings a lot, I have a deep degree of sympathy for the parties who are, taking time out of their lives to choose to participate in this, and a lot of respect for doing that. In the hearing officer's role, she has to weigh a whole bunch of different considerations in deciding how to manage a case like this, including looking at the resources of the forum. So in this case, that's the Office of Administrative Hearings. They're, a body that has, assistants and other folks to help with, production and management of cases, but their resources aren't unlimited. And so they have to make decisions about how to, best kind of balance their resources in managing the case. The hearing officer needs to look at the needs of the parties, the accuracy and integrity of the record, and kind of a host of number of other factors. I think that one can always look at individual case management decisions and say, well, this could have gone another way. There might have been another way of doing this. But that other way, how that would affect the various considerations that the hearing officer, is taken into consideration, it's hard to tell. Another way might be easier for the parties, but might raise more questions about the integrity of the record, for example. And So again, in this sort of thing, there's a fairly wide amount of latitude for a hearing officer's management of the case in a way that that seems to balance these issues as well as possible. You know, for example, the requiring references to a compiled version of the record. You know, that is something that, yes, you know, if you're familiar with the documents that have already been submitted in the case and are now having to provide a different citation to those documents, that is going to take time on the party's part. On the other hand, it has the advantage of preparing a record for appeal. And so that, you know, for example, if the Supreme Court reviews some of these issues, it has one consistent record to look at rather than a bunch of individual documents. And so, you know, again, that's an example of the kind of issue that the hearing officer would be weighing in making these decisions. So my view of these things, again, is that, you know, sometimes these are tough calls, but there's no evidence that I can see of either bias or incompetence in making the decisions that she has here. The last issue that Ms. Gilbert raised and mentioned again here in her oral testimony are the recent summary determination rulings by the hearing officer. There are a couple of different contentions and Ms. Gilbert's issue here. The first is that summary determination should not have been used in this proceeding. That issue is fairly straightforward to deal with. Again, like the request for motions for clarification that I talked about earlier, the council doesn't have a rule pertaining to what types of motions are and are not allowed in a proceeding. And so the hearing officer does have discretion in deciding what types of motions to allow. A motion for summary determination, again, is an extraordinarily common type of motion in a legal proceeding. And, you know, it does have some advantages in being able to, you know, if there are truly no factual issues that could be relevant, you know, on an issue that a party has raised, it can, you know, make the proceeding more efficient and allow the parties and the hearing officer to focus more on the issues that do have live factual disputes. So the second assertion that Ms. Gilbert makes is particularly with respect to an issue that she is involved in, issue LU5, and which the hearing officer, in response to a motion for summary determination, ruled that there were no material issues of fact, and so that issue should be dismissed. You know, I guess on this, I'd just say that the council's decision here is ultimately not to decide whether or not the hearing officer was correct. That time, you know, to look at that decision, there will be opportunities for appeal ultimately of the hearing officer's ruling, and there will be a time in the future for a reviewing body to, you know, to look at that that decision. Here, you know, what we're saying is not whether the decision is right per se. Competency doesn't require to always being right. Judges, hearing officers, agency final decision makers are all overruled with some level of frequency. It's just part of the business. What the council can and should look at in terms of a competency or bias motion is whether or not the hearing officers fulfilled her basic duties associated with the motion. And in this regard, the hearing officer has reviewed the exhibits, the affidavits, the briefs submitted as part of the motion. She stated the appropriate standard for review of a motion for summary determination. She provided a reasoned basis for her decision. And that's crucial because it means that it will be possible on review of the decision to determine what was decided, why it was decided, and whether the decision in the eyes of the reviewing body is correct or not. And So in my view, she's ultimately fulfilled her basic duties here. She's demonstrated competence in doing so. There's no evidence that she has any particular animus towards one or more of the parties here. She made her decision based on her view of the law and facts presented. Again, this isn't a question here today of whether that decision was ultimately right. That's for another forum to decide. I think really, again, the question is, did she do the things that she's required by, rule to do? And, in this case, I think the answer is yes. So, I've just kind of walked through all the different issues that Ms. Gilbert has raised. Again, my kind of summary conclusion here is that, while there are a number of actions and decisions the hearing officer has made that have gone against the limited parties, or Ms. Gilbert in particular, that none of these kind of rise to the level of showing a bias against those parties or lacking competence. They're merely decisions based on the hearing officer's view of the law and facts before her, and essentially trying to do the best that she can. So my overall recommendation is that the motion here be denied. So with that, I will stop. There's an opportunity for any questions you want to ask me, and otherwise you can deliberate and come to a decision on this issue.
Thank you, Mr. Ratcliffe. That was a good staff report. Are there any comments or questions of Mr. Ratcliffe on the issues that he walked us through? If not, is there a motion someone wants to make?
Mr. Vice Chair, I move that the council deny Ms. Gilbert's motion for removal of Ms. Webster as hearings officer in the Boardman to Hemingway contested case. And if we get a second, then we can have discussion.
Okay, we've got a motion on the floor. Is there a second?
I'll second that.
Okay. And that was Councilor Choctut that did the second? Okay, so we've got a motion and a second. So Secretary Cornett, could you call the roll?
Did you want to have discussion, Ken?
Yes, absolutely. I'm sorry. I blew that. So is there discussion on the motion?
Cindy has her hand
Councilor
raised.
Condon?
Thank you. This is more a question on the bias issue. For the first two issues you mentioned, prejudice, showing prejudice, does that have to be an outward show of prejudice, like a statement of prejudice? I'm just not sure how somebody would know the prejudice of a person if it's not stated.
Yes, Councilmember Condon. So yes, bias, outright bias can be very difficult to show in a legal proceeding. The clearest, easiest cases are instances where a decision maker has made some statement, either in the forum itself, in making a ruling, like, making a broad statement about a class of people that maybe the defendant is part of, or in some other form, giving a public speech, whatever that scenario might be. That is very clear. And most of the bias cases that come up relate to instances like that. And that's where there's a distinction between having a generalized view of the law versus, a bias. A decision maker's job is ultimately to, to have a view of the law, to consider the arguments and to come to a conclusion. And so there is a fair amount of leeway given to decision makers, knowing that that's precisely their role, that even if there is a consistent view of the law, that a reviewing court or decision maker may ultimately disagree with, say was poorly reasoned, whatever, that on its own is not enough to show bias, because that is just, the nature of the beast, basically. And parties can vehemently disagree with the reasoning that the, hearing officer or judge used to reach the conclusions, but ultimately that is taken care of by appeal. Telling another tribunal that the lower tribunal got it wrong, rather than, trying to read in, a biased motivation in making that decision, which can be extraordinarily hard to do.
And just a quick follow up on that. And just to be clear, I certainly didn't read or hear anything that suggested that there was any outward show during the hearings or in the past, a written document that showed either animus or bias in any way, animus or making a decision before considering the facts. Those are the two that I think are harder to assess without some outward show of them.
Okay. Are there any other counselors that would like to make comment or further discussion? Okay, hearing none, then Secretary Cornett, could you call the roll on the motion?
Perry Chalktooth,
Yes.
Cindy Condon,
Yes.
Hanley Jenkins,
Yes.
Kent Howe,
Yes.
Jordan Truitt.
Yes.
Motion carries, Mr. Vice Chair.
Okay, let me go then to the next item is the B2H McAllister. It's agenda item C, and it's the B2H McAllister interlocutory appeal. And again, Mr. Ratcliffe, Oregon Department of Justice Senior Assistant Attorney General, will provide an overview of the interlocutory appeal filed by Mr. Michael McAllister, requesting the council to reverse the hearings officer's ruling and order on motions for summary determination of contested case issues, the Fish and Wildlife 13, the Recreation number 2, and the Soil Properties number 2. The council will allow Mr. McAllister and any party who files a proper and timely response to Mr. McAllister's appeal limited time to provide oral argument. So I'm going to turn this back over to Mr. Ratcliffe, and we can see at what point we want to allow that oral argument, and we can discuss the timing of how long we'll allow those comments. So,
Mr. Vice Chair, if I can just
Yes.
kind of jump in, we did
Yeah.
have a potential break at this point, but that's only if council members wanted a break. You can certainly continue to move forward with this agenda item. I just want to make sure if anybody was having the need of a break, at least we gave the opportunity to do that.
This is Hanley. I'd take a break.
yeah, thank you so much. I am going back and forth, and I hadn't got to the agenda. I was moving forward. So anyway, a good idea. How long do we want to take a break for? Do you
5
want a
minutes.
10 or 15-minute break?
10 minutes?
10's great.
Okay, let's go 10, and let's see if it's I have 9:54 right now, so like 5 minutes after 10 we'll start.
Okay, thank you.
Okay, I think I'd already kind of introduced this on to agenda item C, and I'm ready to turn it over to Mr. Ratcliffe to start this agenda item.
Sure. Thank you, Vice Chair Howe, members of the council. So on this one, again, there's been the opportunity for oral argument as you introduced before we went on break. This is Mr. Michael McAllister's interlocutory appeal of rulings made by the hearing officer on summary determination for Boardman to Hemingway issues Fish and Wildlife 13, Recreation number 2, and Soil Protection number 2. So my understanding is that Mr. McAllister is unable to be here today, and that neither Idaho Power nor Odo wish to present oral argument on this, but I'll turn it back over to you, Mr. Vice Chair, to confirm that. If there is no oral argument, then I will pick up and do as I have just done here for Ms. Gilbert's motion and kind of walk through the advice that I presented.
Okay, can we confirm that Mr. McAllister and Idaho Power are not going to be making any oral testimony?
This is Jocelyn Pease for Idaho Power Company council members. I had wanted to, I understand Mr. McAllister is not here, but had wanted to confirm that we did not plan to offer oral argument, but could be available in the event that the council has any questions on these issues. And otherwise, we would plan to rest on the response briefing that we had submitted in response to Mr. McAllister's appeal.
Vice Chair Howe, this is Patrick Rowe, the Department of Justice, on behalf of the Department of Energy. The department also filed a response to Mr. McAllister's motion. Given that he's not available to present oral argument today, the department also waives its oral argument, but is available to address any questions that the council may have.
Mr. Chair, this is Hanley, and I would support waiving the attorney-client privilege for this item as well.
Yes, okay, that's a good, I guess there's not going to be oral testimony today, and let's kind of do a thumbs up on what Hanley's suggestion was there to open discussion on this item. Okay, so Mr. Ratcliffe, you can proceed.
Great, thank you, Mr. Vice Chair. So by way of introduction, again, Mr. McAllister is a party to the 3 issues that we're reviewing here today. And the hearing officer issued a ruling on summary determination on these 3 issues that dismissed the issues from the case. And that had the effect of dismissing Mr. McAllister as a party because these were the 3 issues that he was permitted to raise as a limited party. Because that results in his complete dismissal, he has the right to seek an interlocutory appeal to the council to review the hearing officer's decisions on summary determination now. Ordinarily, if parties remain in the contested case proceeding, a summary determination ruling is not reviewable by the council at this time. So it's that unique circumstance that makes his motion valid. And so what I'm going to do on this is, as I did with Ms. Gilbert's motion, just go briefly over the legal standard for summary determination. And then we can get into each one of the individual issues. And so summary determination, it's it's a process that allows a hearing officer to rule on issues of law where there are no material issues of fact prior to the full evidentiary presentation in a contested case or trial. The idea behind a summary determination motion is basically that it can promote efficiency in a proceeding by narrowing issues down if those issues can be decided on the law alone, and allowing the parties to the proceeding to focus on the true factual issues before the tribunal. So if a motion for summary determination is made, the parties either have to submit evidence or rely on the record of the proceeding as it exists when the motion is made. At this stage in the process, neither the party who's moving for summary determination nor the responding party can rely on mere allegations. So, just simply asserting, I think, the standard is not met. That's not good enough. You need to submit an affidavit or documentary evidence that demonstrates why your position has evidentiary support. So that's what's happened in this instance. There is an existing record here that the parties are all entitled to use. Mr. McAllister has submitted some additional documentary evidence, and that is essentially what the hearing officer is making her decisions based on. Now, the critical part here on summary determination is, well, that sounds a lot like the actual hearing itself. You present your evidence and the decision maker makes a decision. But there's one key difference here and why this is a separate process than the rest of the proceeding is that when a motion is made, the hearing officer looks at the evidence that's been presented, and she must assume that the evidence submitted by the responding party, in this case, Mr. McAllister, that evidence is true. In other words, and the phrase that's used is the decision maker must view the evidence in a light most favorable to the responding party. And so, just to give a concrete example of this, if you have someone who is moving for summary determination on an issue of trespass, if the person who submits the summary determination motion submits an affidavit that says, yeah, I saw this person walk onto my land. And then the responding party says, no, I didn't. I got right up close to the line, but I never stepped over. The decision maker on summary determination is going to assume, purely for the purposes of the motion, that the responding party's affidavit is true, and that the moving party's affidavit is not. That is only for the context of this motion. Once we get past the summary determination phase, if there are still live issues in the case, then the decision maker does what we would ordinarily expect: weigh the evidence and make a decision based on the weight of the evidence. After that kind of initial stage of looking at the evidence and saying, well, okay, I've got to, look at it in the light most favorable to the responding party, in this case, Mr. McAllister, then I need to figure out whether the fact is a material fact. And that is done by looking at the applicable law and finding out whether that fact might affect the outcome of the case. And so again, from our example above, if the law is that stepping onto the land of another person without permission is trespass, then testimony that the defendant came close to but did not step over the property boundary is a material fact. It's going to decide the outcome of the case, or could decide the outcome of the case. To take a absurd example from my memo, in contrast, testimony that the defendant's favorite animal is an octopus is not likely to be material to deciding whether or not the trespass did or not occur. So again, we're looking for something that will help decide the outcome of the case. The last point I want to make here about summary determination is I just talked about the applicable legal standard. In some cases, that's very clear what the legal standard is. And so what the summary determination really is about is, does the responding party have some evidence supporting a material fact? And if not, then, if the moving party under the law is, entitled to a determination, then that's the end of the matter. But in other cases, the responding party may have submitted evidence, but the parties dispute what the appropriate legal standard is. And then in order to know what a material fact is, well, the hearing officer is going to have to make a decision about what the applicable law is. So the example that I used here in our trespass example is that, a defendant might admit that he crossed the property boundary, but only briefly and by accident. So he might argue that the appropriate legal standard is there's no trespass if crossing a boundary is brief and inadvertent. The plaintiff in response might argue that any crossing of the boundary is trespass, regardless of the length of time or intent. In this situation, what the decision maker's got to do first is decide which of those two legal standards is correct, and then figuring out whether or not there are material facts that bear on the decision under that standard. This, in some ways, the motions for summary determination are a little bit more complicated than, simply weighing the facts in the case, because we have to kind of do this, this dance of making assumptions about the truth or not of the evidence in the case. But ultimately, the idea here is, if it's possible to narrow things down just to legal issues, to be able to make a decision on those legal issues before we have to get to the stage of parties going through the full-blown hearing. Again, I'll stop there since I've gotten through the basic description of what a summary determination motion is. See if there are any questions, and then I'll get into each one of the issues that Mr. McAllister has raised.
Councilors have any questions at this point? Okay, I think you can proceed.
Great. Okay, so the first issue is Fish and Wildlife number 13. And the issue here is whether the proposed Morgan Lake alternative route complies with the Fish and Wildlife Habitat Standard. So on this issue, both Idaho Power and Odo moved for summary determination. And there are a number of issues that were raised here on the summary determination briefing in relation to this issue. So I will just walk through each one of those, and then I'll provide a recommendation to the council on each one of the sub-issues. Once I've gotten through each one of the sub-issues, then I'll kind of provide an overall recommendation on the issue itself. So the first sub-issue is issues related to the site boundary. And so Mr. McAllister here is contending that parts of Morgan Lake Park and the Twin Lake wetlands are within the site boundary. Based on this assertion of fact, he argues that Idaho Power has not complied with the Fish and Wildlife Habitat Standard because Idaho Power did not analyze or categorize the Twin Lake wetlands, as they would be required to do if they were subject to review under that standard. After review of the record, the hearing officer found that, while there's an earlier version of the site certificate application that included lands within the boundary of Morgan Lake Park, Idaho Power subsequently amended the application to remove these lands from the boundary. And so from the council's point of view, it's not so important whether this is a withdrawal by Idaho Power of something that they really had wanted included at one point in time but no longer do, or whether this is simply a correction of an error in the mapping. It doesn't really matter from that point of view. Idaho Power is not seeking to develop on this land. Site certificate will not allow Idaho Power to develop on this land. And because of that, it's just outside the scope of the application and the council's jurisdiction. So as a legal matter, then there's nothing for the council to decide or do here. There's no relevant issue of fact. Idaho Power has basically just conceded this area is not an issue. So that's the first issue. And again, if there are any questions as I go through these sub-issues, stop me and I'll be happy to answer questions or discuss them in more detail. So the second sub-issue here is a comparison of the BLM recommended route to the Morgan Lake alternative route. Here, Mr. McAllister is asserting that impacts on fish and wildlife habitat would be reduced if Idaho Power were to develop the BLM recommended route instead of the Morgan Lake alternative. The key here, though, under the law is that the site certificate process that applicants have to go through does not require an alternative site analysis. So in recognition of that, Mr. McAllister is responding that even if the overall site certificate process doesn't require an alternatives analysis, he contends that an alternatives analysis is still required by the Fish and Wildlife Habitat Standard specifically, because he says the standard requires avoidance of impacts through alternatives to the proposed development action. But digging into the Fish and Wildlife, the ODFW rules, the Department of Fish and Wildlife rules that are incorporated here by the council, those rules don't require avoidance except for habitat category 1. For the remainder of the habitat categories, avoidance is a potential mechanism for compliance, but if the impacts are unavoidable, there are alternative compliance mechanisms that depend on what other category the habitat is designated as. But because the site certificate requirement as a whole doesn't include an alternatives analysis, the site boundaries themselves are driven by the applicant. The council is only reviewing what an applicant brings before them. And that effectively determines, for the purposes of the Fish and Wildlife Standard, what is and what is not avoidable. So, if this were a situation where there was category 1 involved, it would essentially be up to the applicant. They know that they can't develop there. So they would have to, say, well, we are choosing to reconfigure our project boundaries in order to be able to, continue to develop. But that's not the same thing as a full-blown alternatives analysis requirement. That's just basically, a mandate that, the applicant has to deal with. Although Mr. McAllister is correct about this avoidance language in the rule, the way that it plays out in relationship to the overall council standards, it's not the same thing as requiring a full-blown analysis, alternative analysis. And so Idaho Power here was not required to have compared the relative fish and wildlife habitat impacts of the two different route options. Instead, they're just required to meet the requirements for the route that they have chosen. As a result of that, my recommendation on that one is that there are no material facts in dispute. So the last sub issue under Fish and Wildlife 13 is the sufficiency of the analysis area. And here, Mr. McAllister is contending that the project analysis area is inconsistent with the Fish and Wildlife Habitat Standard. He's alleging that areas outside the analysis area will suffer impacts to fish and wildlife habitat and therefore should have been analyzed. So the analysis area is a concept in the council's rules, and it's defined as the area for which the applicant must describe the proposed facility's impacts in the application for a site certificate. The analysis area and the process gets defined by the project order. And so we have a project order in this application that defines the areas the applicant must look at in order to demonstrate that it meets standards. Different analysis areas can be applied to different standards. So the width of an analysis area for fish and wildlife habitat may not be the same as for soil protection or protected areas. So there can be discrepancies there. But the key characteristic is that in each case, the applicant has got to look within that analysis area to demonstrate compliance. Conversely, it is not required to look outside those analysis areas to demonstrate compliance. On this one, and this is my recommendation here is consistent with what the hearing officer found. The correctness of the analysis area appears to be outside the scope of Mr. McAllister's issue, precisely because compliance with the Fish and Wildlife Standard is determined by the analysis area. It's when you're challenging whether or not the applicant met the Fish and Wildlife Habitat Standard, as he is here, by definition, you're saying, well, within the area that they were required to look, have they demonstrated compliance? And my view is that, for Mr. McAllister to assert that the department should have chosen a different analysis area, that's really kind of a separate question, not something that was raised on the DPO record and not that was a part of the issue that was ultimately defined by the council. In addition, on this one, it doesn't appear that Mr. McAllister submitted facts in support of the position that areas outside the analysis area will be affected. Rather, it looks more like he's making assertions without factual support. It kind of, well, there must be impacts outside this area, essentially, without backing that up on the record. So as a result of all that, my recommendation on this one is that there are no material facts, issues of fact in dispute on that sub-issue. I've now walked through each of the sub-issues, and because of recommending that there don't appear to be any material issues of fact on any of the sub-issues, my overall recommendation is that the council affirm the hearing officer's ruling on summary determination, which dismisses this issue from the contested case proceeding. So again, I'll stop there, see if there are any questions. And my suggestion here, although it's not a requirement, is that the council go ahead and vote on each one of these sub-issues, vote on each one of these issues separately, like Fish and Wildlife 13, before moving on to the next issue, just because I think it may help us all keep the issue more front and center, rather than having to kind of think back to the other ones and do it all at the end. But that, again, that's up to the council.
Okay, councilors, do we have let's see, Mr. Ratcliffe, you were suggesting there that we kind of make a motion on where we're at this point in the presentation.
Yes, again, that's up to your discretion, but, there's a fair amount of material here.
Yeah.
And so I thought maybe it just could be simpler to do it that way.
Yeah, that makes sense.
So Kent, this is Hanley, and I'd attempt a motion here for the Fish and Wildlife 13 issue.
Okay.
Okay, I move that on Fish and Wildlife issue 13 and Mr. McAllister's interlocutory appeal, that because there do not appear to be any material issues of fact in dispute with respect to this issue, that the hearings officer's ruling on summary determination dismissing this issue from contested case proceedings be upheld.
Okay, we've got a motion. Is there a second?
This is Jordan. I will second.
Okay, we've got a motion and a second. Is there any discussion? Okay, Mr. Secretary, could you please call the roll?
Jordan Truitt,
Yes.
Hanley Jenkins,
Yes.
Kent Howe,
Yes.
Cindy Condon,
Yes.
Perry Chalktoot.
Yes.
Motion carries, Mr. Vice Chair.
Okay, I think you're ready to proceed, Mr. Ratcliffe.
Thank you, Mr. Vice Chair. So the next issue before the council on the interlocutory appeal is issue recreation number 2. The issue here is whether the visual impacts of the proposed facility structures in the viewshed of Morgan Lake Park are inconsistent with the objections of the Morgan Lake Park Recreational Use and Development Plan, and should therefore be reevaluated. Idaho Power moved for summary determination on this issue. And again, as I did with Fish and Wildlife 13, I'll describe the sub-arguments in the briefing and provide the council with recommendations. So the first issue here, as it was with Fish and Wildlife 13, is again the site boundary. Idaho Power's motion in this case is asserting that facts pertaining to compliance with Morgan Lake Plan are irrelevant because Morgan Lake Park is not within the site boundary. And Idaho Power is not required to demonstrate compliance with the objectives of the plan to demonstrate compliance with the council's recreation standard. Again here, just as to the question of the site boundary, we'll talk about the relevance of Morgan Lake Park and its plan to compliance with the recreation standard in general later, but specifically with respect to the boundary, again, as with Fish and Wildlife 13, the circumstances that an earlier version of the site certificate application included lands within the boundary of Morgan Lake Park. Idaho Power amended the application to remove these lands from the boundary. And again, they're not seeking permission to develop on this land. Site certificate won't allow them to develop on the land. And so just on that issue alone, there don't appear to be material facts in dispute with respect to the site boundary. The second issue is the scope of the issue itself. And here in Mr. McAllister's response to Idaho Power's motion, he's contending that his issue is broader than it is described in the council's order on issues, and he should be more generally permitted to raise compliance with the recreation standard and any kind of arguments he can make under that. The hearing officer's ruling here rejected this and concluded that the issues in the contested case are limited to those raised with sufficient specificity in the person's comments on the DPO. The hearing officer is absolutely correct that limited parties are not able to expand their issues at this stage. OER 345, 15, 16 sub 6 provides that the hearing officer's ruling on party status, which includes rulings on the issues the parties are permitted to raise, is final unless the requested person submits an appeal to the council. The hearing officer's already ruled on Mr. McAllister's petition for party status. That ruling is final. However, I do have some concerns with some other statements made by the hearing officer in reaching this decision. I think the ruling goes too far by reaching back to the comments made on the DPO record and attempting to sort of reinterpret them at this stage in the proceeding. Again, the issue statement's already been ruled on. It's final. I don't think the hearing officer has the authority to further limit issues at this stage of the proceeding, just as she doesn't have authority to broaden them. And so Mr. McAllister's issue that the council is looking at for the purposes of summary determination, I believe, is precisely as it is described, no more, no less. And so that, you know, there's not necessarily facts in dispute here. This is more kind of a case just purely of legal interpretation, which is, you know, also appropriate on summary determination. And so my recommendation here is just that his issue is the words on the page, and can't be narrowed or expanded at this stage in the proceedings. So then the third and final sub-issue here, and this is really kind of the heart of things on recreation number 2, is that concerns the relevancy of facts that pertain to the consistency of the facility with the objectives of the Morgan Lake Plan. So what Idaho Power is arguing here is that it doesn't have to comply with the objectives of the Morgan Lake Plan to satisfy the council's recreation standard. And so Idaho Power argues then it follows that any evidence of inconsistency with the plan is irrelevant, and Idaho Power is entitled to summary determination. The hearing officer's ruling agreed with that, and noted further that the Morgan Lake Plan cannot bind development outside of Morgan Lake Park's boundaries. And so here, just as a purely legal matter, I think that Idaho Power and the hearing officer are correct that compliance with the Morgan Lake Plan, strict compliance, is not required to meet the standard. The standard remains, you know, as it is defined in the council's rules, and those rules don't require strict compliance with the Morgan Lake Plan. But at the same time, I think the relationship between the project's visual impacts and the Morgan Lake Plan may bear on the recreation standard, depending on the facts that are presented. So let me just scroll down here so that I can get to the standard itself. Bear with me for just a second. Okay. So here, I think the issue is that the facts provided by Mr. McAllister may be material, even though his issue doesn't broadly cover compliance with the recreation standard. The facts would instead be material because the reevaluation of the significance of the facility's visual impacts with respect to Morgan Lake Park is potentially one component of the council's overall determination of compliance. So turning to the recreation and standard itself, this is Rule 345.22.100 sub 1. And the standard provides that the council must find the design, construction, and operation of a facility, taking into account mitigation, are not likely to result in a significant adverse impact to important recreational opportunities in the analysis area. The council then must consider a set of factors in judging the importance of the recreational opportunity, including any special designation or management of the location, and some other factors, including the degree of demand, outstanding or unusual qualities, and et cetera. So to kind of break it down into parts here, the council has two tasks in determining compliance with the recreation standard. First, it's got to decide whether or not a recreational opportunity is important. It does that by looking at the listed factors. If the council decides that a recreational opportunity is important, it then has to evaluate the impacts of the facility and determine whether they're significant after taking into account any mitigation. This then requires the council to use its rule defining what significant means. And here that's defined as having an important consequence based on the magnitude and likelihood of the impact on the affected human population or natural resources, or on the importance of the natural resource affected. And there's a number of considerations that the council can use to try and reach that conclusion. So I think, as relevant to Mr. McAllister's issue here, it's important that the council's rule defines significance in terms of both the resource itself and the importance of the resource. And again, the importance of the resource is determined by the factors listed in the recreation standard, which include a special designation or management of the location. This is a bit of a winding path to get here, but I think what's important is that Mr. McAllister has asserted facts, provided documents that may ultimately be relevant to the outcome of the council's determination on the recreation standard. Even though his issue is more limited than that, if he still has facts within the scope of his narrow issue that could feed into the recreation standard, that's still relevant to the overall determination of the recreation standard. Among the values that are expressed in the Morgan Lake Plan are to preserve the maximum of natural setting and to encourage solitude, isolation, and limited visibility of uses. Mr. McAllister submitted evidence concerning the visibility of facility components from the park, the use of the park by its visitors, the perception of changes to the visual landscape by park visitors, among other things. And it's my recommendation that these asserted facts are relevant to the consistency of the visual impacts with the Morgan Lake Plan, and therefore they bear on the importance of the resource. And under the department's definition of significant impact, a bearing on the importance of the resource ultimately bears on the significance of the impact, and therefore on the recreation standard. So in my view on this one, although again, we have to take a few steps to get there, I think those are logical steps. I do think that there are material issues of fact in dispute with respect to this issue. Because of that, my overall recommendation is that the council overrule the hearing officer's granting of summary determination on this issue, reinstate the issue, and reinstate Mr. McAllister as a limited party for the purposes of the issue. Now, before we get to discussion, there's one thing that I want to make really clear here. And that is that what I've said in this analysis is not the same thing as saying that Idaho Power is required to comply with the Morgan Lake Plan. It is instead the fact that there is an overlap, between the Morgan Lake Plan and the recreation standard, because the Morgan Lake Plan and its goals are one of the things that make Morgan Lake Park and the recreational opportunity there important. And if you provide facts that say that, there are visual impacts on the park that affect those values, theoretically, there could be a diminishment of the value of that recreational opportunity, of its importance, and that bears on the recreation standard. So there is a relationship between the two, but the council's decision, which is not making today, this is going to be a part of the final decision on the site certificate, is whether or not the recreation standard is met by looking at the specific words of the recreation standard rule. Having relevance between the facts that Mr. McAllister's asserted, having relevance between the plan and the standard is not the same thing as a requirement. So anyway, hopefully I have made that clear, but it is, it's kind of a difficult thing, right? Because the entire issue is framed in terms of the Morgan Lake plan. And so then that kind of leads one perhaps to think that that's really the compliance issue here, but it isn't. It's just, we're talking about a subcategory that feeds into the recreation standard. So I will stop there, see if there are any questions or discussion, but otherwise I think that's the end of my presentation, and the council can take motions on this issue.
Any questions or discussion for Mr. Ratcliffe on this recreation issue?
This is Hanley, and I would agree that Mr. Radcliffe has refined the issue here, and that it's very important that what he is proposing is not that there be compliance with the Morgan Lake plan, and that what we're addressing is the factual issues that Mr. McAllister has submitted as evidence, and the issues of visibility. I'm prepared to make a motion, and I think I'll go ahead and do that, and then if there's a second, we can have discussion on the issue. So under this item R-2, because there are material issues of fact pertaining to issue R-2, I recommend that the council overrule the hearings officer's granting of summary determination, reinstate issue R-2, and reinstate Mr. McAllister as a limited party for the purpose of issue R-2.
Okay, we have a motion. Is there a second?
This is Cindy. I'll second that motion.
Okay, we've got a motion and a second. Is there any further discussion? Okay, if not, then Secretary Cornett, could you call the roll?
Hanley Jenkins,
Yes.
Kent Howe,
Yes.
Cindy Condon,
Yes.
Perry Chalktoot,
Yes.
Jordan Truitt.
Yes.
Motion carries, Mr. Vice Chair.
Okay, then I guess we're ready to move on then to the soil protection issue. So it's back to you, Mr. Ratcliffe.
Thank you, Mr. Vice Chair. And this is the final issue that we're going to be dealing with on Mr. McAllister's interlocutory appeal. The issue is whether the Morgan Lake alternative route complies with the soil protection standard. On this one, both Idaho Power and Odo moved for summary determination. And again, as I've done before, I will go over the sub-issues involved here and provide recommendations as to each sub-issue before providing a broader recommendation. So the first sub-issue is a comparison of the route alternatives. So Idaho Power's motion is asserting it's entitled to a favorable ruling as a matter of law because Mr. McAllister, is what he's done is compare the soils along the two routes. One of them, the BLM recommended route, and the other, the Morgan Lake alternative route. And so Idaho Power is saying that a comparison per se is not relevant to whether the Morgan Lake alternative route, whether there will be significant adverse impacts to the soil as a result of that development. Idaho Power argues that because the council lacks jurisdiction to address a route that's not proposed in the site certificate, any comparison between the predominant soil types and resulting adverse impacts is immaterial. And we talked about this a little bit in reference to Fish and Wildlife 13. The site certificate process does not require an alternative site analysis. Mr. McAllister has presented evidence of the characteristics of the soils within the Morgan Lake route alternative. He's compared those soils to an alternative route that is not a part of Idaho Power's application, but he's not provided facts that pertain to the adverse impacts of the facility on the soils within the Morgan Lake alternative route. In other words, simply comparing, a soil type between one area that is proposed, one area that is not proposed as part of the site certificate. Well, that may tell you, relative values, but it's not telling you anything about the overall issue at hand, which is, is the development going to result in adverse impacts at this place? So my recommendation on this sub-issue is that there are no material facts, issues of fact in dispute, and that the hearing officer's decision on this sub-issue was valid. So the next issue is site boundary, which we've already talked about before, but again, in reference to this particular issue, Mr. McAllister is again contending that the site boundary is incorrect, that Morgan Lake Park and the Twin Lake wetlands are within the site boundary. But as discussed above on both the issues, well, there was an earlier version of the site certificate that did include those lands. Idaho Power has amended the application, and so they're not seeking permission to develop on that land. Site certificate won't cover it. It's outside the scope of the application and the council's jurisdiction. So a ruling on summary determination on the sub-issue was appropriate, and the hearing officer's decision was valid. The last issue here pertains to the analysis area. In response, and this is responding now to Odo's motion, even though motions were filed on the same issues, Odo and Idaho Power, in a couple of instances covered slightly different topics. So in response to Odo's motion, Mr. McAllister contends that the analysis area is incorrectly limited to the site boundary, and this will result in unmitigated significant impacts to soils outside the analysis area. Again, in reference to Fish and Wildlife 13, we talked about what the analysis area is. It's determined by the project order, and the correctness of the choice of analysis area appears to be outside the scope of Mr. McAllister's issue. Idaho Power doesn't need to demonstrate compliance with the standards outside of that area. In addition, on this analysis area issue, Mr. McAllister doesn't appear to have submitted facts in support of his position that areas outside the analysis area will be affected. Rather, he's making assertions without actual support, such as a general reference to the carbon sequestering characteristics of soils. And so a secondary basis for ruling on the sub-issue is just simply that he hasn't raised material issues of fact. So my recommendation on that sub-issue is there are no material issues of fact in dispute. And just in general, the summary of the recommendations is there don't appear to be any material issues of fact in dispute. So I'm recommending on this one that the council affirm the hearing officer's ruling, which dismisses this issue from the contested case proceeding.
Okay, do we have a motion on soil productivity issue number 2?
So this is Hanley, Vice Chair, sub-issue SP-2. Because there do not appear to be any material issues of fact in dispute with respect to this issue, I recommend that the council affirm the hearings officer's ruling on summary determination dismissing this issue from the contested case proceeding.
Do we have a second?
I'll second it.
Okay, we've got a motion and a second. Is there any discussion? Okay, then Secretary Cornett, could you please call the roll?
Cindy Condon,
Yes.
Perry Chalktooth,
Yes.
Jordan Truitt,
Yes.
Hanley Jenkins,
Yes.
Ken Howe.
Yes.
Motion carries, Mr. Vice Chair.
Okay, so I believe that does it for item C. And I, now that we've concluded both agenda items B and C, I'll return running of the meeting back to Chair Grail. And again, thank you, Mr. Ratcliffe, for your thorough presentations on items B and C.
Thank you, Mr. Vice Chair, members of the council.
Thank you, Jesse.
Thank you. Thanks so much, Kent, for taking care of that. And Jesse, again, thank you for your portion as well. So the next item we have on the agenda is a project updates. So Odo project leads will provide brief updates on their active projects. I believe Katie Clifford is going to start us off. Good morning, Katie.
Good morning, Madam Chair Grail, members of the council. Can everybody hear me all right?
Yes.
Yeah.
Great.
Yes.
Thank you. For the record, my name is Katie Clifford, and I'm a senior siting analyst with the department. My colleagues Wally Adams and Chase McVay Walker and I will be providing updates on projects under council review. During the July council meeting, senior siting analyst Kellen Tardyweather provided updates on 1 transmission line and 5 solar energy projects. Those are the Boardman to Hemingway project, Obsidian Solar, West End Solar, Blue Marmot Solar, Archway Solar, and Lake Oven Solar projects. Today, we will provide updates on 3 solar projects, 1 wind project, 1 combination wind and solar project, a system reliability project, and a proposed renewable diesel production facility. The first is the Bonanza Energy Facility, which is a proposed solar photovoltaic or PV energy generation facility with a generating capacity of between 150 megawatts and 300 megawatts, depending on the solar module technology selected at
Can I
panel
jump in
design.
real quick? We don't have the PowerPoint up, so it's either Donita needs to get the PowerPoint up or have you do it. So I'm not sure who is going to run it, but there are slides associated with this agenda item.
My apologies. I thought I was screen sharing, and I will fix that right away. Thank you for letting me know.
Sure.
Can you see my screen now?
Not, yeah, it's coming up. Yep.
Okay. Thank you
Now
so
you're
much
good.
for
Thank you.
telling me. That's important.
Okay.
Great. All right. So the first is the Bonanza Energy Facility, as I said, a solar PV facility. The applicant is Hecate Energy Bonanza LLC, who proposes to develop the facility in Klamath County on approximately 2,733 acres of private land. The solar array itself would occupy approximately 1,800 acres, which is roughly equivalent to 2.9 square miles. The facility would be located approximately 1 mile southeast of the town of Bonanza. So as you'll see on this slide, the maroon outline in the upper portion of the slide shows the limits of the city of Bonanza. Bonanza itself is located approximately 25 miles east of Klamath Falls. In addition to the solar array, the proposed facility would include electrical collector lines, inverters and transformers, an on-site facility substation, and an 8-mile-long 500 kilovolt transmission line with a point of interconnection at Bonneville Power Administration's substation near Malin. The facility would also include an operations and maintenance building, service roads and gated access points, access roads and construction areas, as well as an up to 1,100 megawatt battery storage system. The battery storage system, just to give you a sense of scale, would be housed in up to 11 separate enclosed structures that would occupy approximately 91 acres. The applicant submitted the notice of intent last year on August 7th, and following that, on October 13th, the department hosted a public information meeting to discuss the notice of intent and the FSEC process. During the 61-day comment period, which was extended based on public requests, the department received 18 comments from government entities, 6 comments from stakeholder groups, and 89 comments from members of the public. So for an early stage of the process, that was a pretty substantial amount of participation. We anticipate receiving the application during the first quarter of next year. In the meantime, we understand the applicant is meeting with local stakeholders and doing necessary field survey work. And even though we're not in a formal comment period on the project, we continue to receive regular comments and questions from members of the public, asking questions and supporting or opposing the project. On October 18th, so quite recently, the community opted to host their own meeting to discuss the proposed facility. So just to be clear, that was not a council meeting or an ODO meeting. And based on communication with one of the meeting organizers, we understand that the issues discussed at that meeting include concerns about impacts to big game winter range, water rights, public safety, and loss of agricultural land and rural character. So those comments that we understand were discussed at that meeting are similar to what we saw during the NOI public comment period. I will pause here to see if council has any questions about this project. Hearing none, I will move on. The next project update is the Nolan Hills Wind Power Project. Despite the name, this is a proposed wind and solar PV energy generation facility. The applicant, Nolan Hills Wind LLC, proposes to develop the 600 megawatt facility within an almost 16,000 acre micrositing corridor in Umatilla County. The proposed facility would be located south of Interstate 84, approximately 4 miles south of Echo and 10 miles west of Pendleton. The external outline on the slide shows the site boundary, and the purple shading shows the micrositing corridor, which would contain the wind turbine strings, access roads, collector lines, and the internal 6.8 mile, 230 kilovolt transmission line. The solar and battery storage components are represented by the larger solid purple shading area in the northeast portion of the site boundary. The facility would interconnect to BPA's transmission system in either one of 2 ways, and both ways are shown on the slide. They're seeking permitting options for both. And the first route is known as the UEC Cottonwood route, UEC standing for Umatilla Electric Cooperative. And that would consist of 8.4 miles of new 230 kilovolt transmission line and modification of almost 17 miles of existing UEC transmission lines. The Cottonwood route would run west from the Northern Facility Substation to the UEC Cottonwood Substation, and then existing lines would deliver the power north to BPA's McNary Substation near the Columbia River. The second option is known as the BPA Stanfield route. This would consist of a new overhead 4.5 mile, 230 kilovolt transmission line, and that would run from the Northern Facility Substation to BPA's Stanfield Substation. BPA has not yet built the Stanfield Substation, so that's one reason for the 2 different transmission line options in their request. At this time, the developer is revising their preliminary application to respond to our request for additional information, but For those parts of the application where we have sufficient information, we've begun drafting the draft proposed order. Does the council have any questions about this project?
Madam Chair, this is Hanley. Katie, how much of the 600 megawatts is solar versus wind? Do you know?
I do, and that would be, I'll just check in here. Okay, the solar is estimated at approximately 260 megawatts and wind would be about 340 megawatts. But they do hope to have the flexibility based on market conditions at that time to modify how much goes to each component.
Is there any battery storage proposed?
Yes, and sorry to not be clear about that. So the battery storage components would be located around where you see the solar component, and that is that solid outline in the northeastern corner of the site. So the battery storage would either be distributed throughout that area where the solar components are, or it would be in the northwest portion around where the solar component is, but all grouped together and near the northern facility substation.
Do we know the capacity of that?
I can double check on that and get back to you soon.
Okay, that's okay.
I think it's
Thank you.
around 100 megawatts, but I will double check on that.
Chair Grail.
Yes, go ahead, Cindy.
This is Cindy. Thank you. Katie, just a question. Given the large public input, I guess, or engagement, and this is more about process, your process, or our process, I should say. How do you incorporate, so the applicant is responding to questions, we're drafting the proposed order. How are you incorporating the comments that we're getting, not particularly on the record, but there's a lot of activity? How do you take that in and as you're drafting the proposed order?
Sure. Thank you, Councilmember Condon. And is this a question for Nolan Hills or Bonanza or just generally?
Generally, but given the large public input on this one or interest, it seems, and partly because this is, I think, one of the first that I'm involved from the beginning. I went to the NOI, so I'm curious in the process for this one
Sure.
particularly.
That's a great question. Thank you. So this actually is a good question for all the updates I'm giving today. So specifically so I'll talk about Bonanza first, the Bonanza Energy Facility, the one that it's not in an active public comment period, but where we are receiving a number of questions about that. So I'll go back to that one real quick. And because we don't have an application right now, the way that I'm handling it is just in terms of a public servant's role of answering questions, providing process information, listening. When we receive a request to pass along comments to the council, I will send that to Secretary Cornett and he'll make sure that we're able to package it so that we're not overwhelming council with emails. But at this time, it's in terms of any issues raised by the public, because we don't have an application to review yet, it's more informative for us and then an opportunity for us to share information about process. And then that differs from Nolan Hills, where there have been a few comments that have come in. So I'll move back to that one. And, you know, I would have to say, in contrast, we haven't received as many comments. Now, that doesn't minimize the impact of the comments on Nolan Hills, but I would say comments have been most interested or most concerned about the transmission line routes. And so as we were going through reviewing the application and developing the request for additional information, the applicant elected to add an additional sub-route to the BP Stanfield route based on some of those comments coming into us. And that was based on some concerns about the initial route they had selected. And so they have one that is very close, but, you know, just on the other side of an important boundary line.
Okay, thank you. And sorry, I had Bonanza at the top of my mind. It was that I was thinking of, but both of them, I appreciate the comments about both of them.
That's a great question. And you know, we've also been getting comments on Eugene and Medford which is the next one I'll talk about. And so as part of that, you know, I tend to still be in the role of answering questions. A lot of what I emphasize to folks is that if we're not in an active public comment period, all those comments are considered. I certainly save them, but if people are really interested in participating further, you know, in the later stages of the process, something really important to emphasize is that they need to participate at the draft proposed order stage. And so any comments I get, I try and let people know that they'll want to continue to participate if they're concerned about the project.
Great, thank you.
So Madam Chair, this is Hanley.
Go ahead, Hanley.
Katie, you do have a preliminary application for Nolan Hills, correct?
That's correct, Councilmember Jenkins.
But you just haven't determined that it's complete yet, according to the slide here.
That's correct.
Okay.
Yes, and so in our process, as you know, we don't have an obligation to begin drafting the draft proposed order until an application is found complete.
Right.
But where we have any capacity, we certainly try to for those particular exhibits where we do have sufficient information.
Yeah, so there is some information available for the public in the preliminary application on Nolan Hills.
That's correct. And that's
Okay.
posted to the website.
Okay, thank you.
Yeah. Great. And to be clear, there for Nolan Hills, for Bonanza, for any project that's going through the standard review process for a new application, there will be a meeting or, you know, it's at the department's discretion, but there can be a meeting at the completeness determination phase where the department finds an application for site certificate complete. Then the public's made aware of that. And then that occurs before we release the draft proposed order. So that's an opportunity to talk with folks about next steps in the process, what's in the application, and how they can participate once the draft proposed order is released. Okay, well, I will move on to the next project update and feel free to let me know if you have additional questions. The next update is request for Amendment 4 to the Eugene to Medford Transmission Line Site Certificate. PacifiCorp's Eugene to Medford Transmission Line is an operating 500 kilovolt transmission line that runs 146 miles from PacifiCorp's Spencer Switching Station, which is south of Eugene, to PacifiCorp's Meridian Substation near Medford. The council first issued a site certificate for the facility in 1982. So this is one of your older facilities. PacifiCorp seeks approval to expand the site boundary and develop additional transmission infrastructure in Josephine and Jackson counties, including through a small segment of the city of Rogue River. So I have two figures to show next to help give a sense of where all these features would be. The overview figure here shows a portion of the existing Eugene to Medford transmission line in blue. And then the request for Amendment 4 components are shown in red here. There's a yellow triangle at the intersection of these two features, the blue line and the red line, so the existing transmission infrastructure and the proposed new transmission infrastructure. And that yellow triangle near Sam's Valley is known as the proposed Sam's Valley substation, which would connect the new and existing infrastructure. This slide shows only the request for Amendment 4 component, so zoomed in a bit. As part of request for Amendment 4, PacifiCorp would replace 17.6 miles of existing 115 kV transmission line between Grants Pass in Josephine County and Sam's Valley in Jackson County. Now they would replace that with a new double circuit line, which would have 230 kilovolts on one side and 115 kilovolts on the other. In addition, they would reconductor 4.9 miles of an existing 230 kV transmission line between Sam's Valley and the proposed new Sam's Valley substation and the Whetstone substation, which already exists, and that's near White City. A new 500 and 230 kilovolt substation, the one I referred to before, Sam's Valley substation, would be developed on approximately 17 acres just south of Highway 234 and just north of Lower Table Rock. Existing access roads would be temporarily improved to construct these proposed new facilities. Collectively, these components are known as the Sam's Valley Reinforcement Project. So you'll hear us refer to EMT AMD4, as our shorthand, or to Sam's Valley. The Sam's Valley Reinforcement Project is intended to address deficiencies in the regional transmission system to reduce the risk of power outages in Jackson and Josephine counties. At this time, we're awaiting additional information about mitigation for impacts to cultural resources before we find the request for amendment complete and release the draft proposed order. Now for this one, because we have the information we need, but for, one standard, albeit a really important piece, we've been able to draft a lot of parts of the draft proposed order, but, we still need that additional information before we can move forward with finding the request complete. So at this point, I'll be happy to answer any questions you may have.
Yeah, Madam Chair, this is Hanley.
Go
Katie,
ahead, Hanley.
are they expanding the right of way for this replacement between Grants Pass and Sam's Valley?
That's correct. Yes. Thank you for that. And so, Councilmember Jenkins, and so they would need to expand the right of way because the 115 kilovolt transmission line has required clearances, but then if you move up in voltage by adding the 230 kV circuit, they need to expand out. And so the total right of way would end up being about 135 feet. And for most of the line, that would be moving out an additional 35 feet. It really depends on the land ownership type, but it would definitely involve an expansion.
Okay, thank you. So that's why they're having to do the cultural resources evaluation, is because they're expanding the right of way.
Yes, and even the other elements, the reconductor portion of the line, for example, running between the proposed Sam's Valley substation and Whetstone, there's some sensitivity there. The bigger or another area that may have a high potential for cultural resources that we're not aware of and has one cultural resource that we're very well aware of, a traditional cultural property, and that's Lower Table Rocks. And so that would be impacted by the Sam's Valley substation. And so based on the various features, in particular the substation, there's additional work going on at the federal review level for Section 106. And that was triggered because the Bureau of Land Management would have to authorize the transmission line, which goes through their land. And then under the National Environmental Policy Act, the substation, even though that's on private land, PacifiCorp owns that land, it's treated as a connected action. And so all of that has gotten wrapped into government to government consultation in Section 106 of the National Historic Preservation Act. And rather than duplicating that process, we've been waiting to see the outcome of the Section 106 negotiations to reach a memorandum of agreement. And so that would impact, or that involves the Confederate Tribes of the Grand Ronde, the Cow Creek Tribe, and the Siletz Tribe. And of course, BLM, PacifiCorp, and SHPO are involved in that discussion.
Wow. Okay, thank you.
Okay, unless there are any other questions, I will turn the presentation over to our Operations and Policy Analyst, Wally Adams.
Thanks, Katie.
Thank you, Katie. Can you pass me presenter rights?
Absolutely. Maximizing the screen again to do that. And I confess the I just have the tiny WebEx screen. It doesn't want to maximize for me.
Maybe maybe Donita can help us out. Oh, looks
There
like
we go.
There we go.
And Wally, you have the ball.
All right. Hopefully everybody can see my screen now. So
Yes, we can see it. Thanks, Wally.
Great. So hello, members of the council, Chair Grail. For the record, my name is Wally Adams. I'm an operations and policy analyst with the Oregon Department of Energy. So I'm going to talk today about the Port Westward Renewable Diesel Project. This is actually a request for an exemption from the requirement to get a site certificate. It's for a renewable diesel production facility. It would be capable of processing up to 50,000 barrels per day of renewable biomass feedstocks. In case you're curious, what that means is basically vegetable oils and animal fats is what they've said that they would use as the feedstock for this facility. It would be located at Port Westward Industrial Park in Clatskanie in Columbia County. The applicant is Next Renewable Fuels. And the status is that we've determined the request to be incomplete. At this time, it's waiting on local land use approval. So there are 5 criteria that have to be met in statute in order to qualify for the exemption from the requirement for a site certificate. And one of those is that the facility has received local land use approval under the applicable acknowledged comprehensive plan and land use regulations of the affected local government, and that the facility complies with any statewide planning goals or rules of the Land Conservation and Development Commission that are directly applicable. So that's the requirement that hasn't been met. Once evidence of land use approval has been provided, then we can find the request for exemption to be complete, and then we can bring it to council for consideration. And once it's determined to be complete, we're required to do that actually within 60 days. Let's move to the next slide. This is a map that shows the location of the facility. You can see it's at Port Westward Industrial Park in Columbia County. The total area, including the site, the access roads, and the rail logistics, is 127 acres. And basically, they will take advantage of the proximity to the deep water port for the transport of both their feedstock and their finished goods. They've stated that over 85% of the biomass feedstock required and the biofuels produced will be transported by ship or by barge. And they've also stated that almost all the remaining 15% will be transported by rail. So they don't expect to transport much of anything by truck. It'll all be either by ship or by rail. Then finally, this is a satellite view of the area, and you can see kind of starting down here in this lower right corner and going up diagonally across the top of the screen. This is the main rail line. And they're proposing to construct a rail spur down here where it says railroad access. That spur will cross land that's currently zoned as PA 80 or primary agriculture. It's also considered to be EFU or exclusive farm use. There are exceptions which may allow the spur to be constructed, and they'll be considered by the county as part of the land use approval. So I think that covers it for now. I don't know if anyone has any questions. If not, I will turn it over to Chase. Okay. Let's see. I think Chase, you have presenter rights now.
Thank you, Wally. Let's see. Okay. Well, first, can everyone hear me all right? And can everyone see my screen?
Yes.
Yes.
I confirm both.
Okay, cool. And before I get started, I wanted to let Councilmember Jenkins know via Katie that the battery storage for Nolan Hills would be 120 megawatts in response to your question. So the battery storage for Nolan Hills would be 120 megawatts.
Thank you.
Yep. let's see, sorry, now. Okay. Good morning, Madam Chair Grail, Vice Chair Howe, and members of the council. For the record, my name is Chase McVeigh Walker, and I am a senior siting analyst with the department. The Wagon Trail, I'm going to start my project updates with the Wagon Trail Solar Project. The Wagon Trail Solar Project is a proposed solar photovoltaic energy generation facility with a generating capacity of approximately 500 megawatts. The applicant for the Wagon Trail Solar Project is Wheat Ridge East Wind LLC, a wholly owned subsidiary of NextEra Energy Resources. And they propose to develop the facility in Morrow County near the city of Arlington. And the proposed facility would be located within a 7,339 acre site boundary, which is equivalent to approximately 11.5 square miles. However, as represented in the NOI, the solar array itself is only anticipated to occupy approximately 5,000 acres of those 7,339 within the site boundary. Related or supporting facilities include, among other things, a distributive energy storage system, lithium-ion batteries, and an 8-mile, 230 kilovolt transmission line. The department previously received a notice of intent for this facility in November of last year, November 2020, and the department issued a public notice on the notice of intent in November as well, and held an information meeting for this facility and the NOI in January of this year, 2021. Due to modifications of the proposed facility, the applicant submitted an amended NOI in June of this year, on June 11th, 2021. And the department anticipates the applicant providing or submitting a preliminary application for site certificate later this month or early next month in September 2021. And just a couple weeks ago, on August 17th, the department released its first amended project order based on the amended NOI. Now I will go into a couple figures. Here is a map of the proposed facility's site boundary in relation to Highway 84. And up here in this top corner is, in the top left corner of the screen is the Columbia River. And Lexington is to the south. Arlington is on 84, a little bit to the west, and it is directly beneath the Boardman bombing range, which is this large area without any irrigated crop circles. And then I will go into one more figure. This is a snippet I took of our department's GIS mapping tool from our website. And here, hopefully this helps to further illustrate where the facility is located and where it's located in association with other approved facilities. The Wagon Trail Solar Facility here in this figure is represented as the blue polygon. The green polygon on this screen is the Wheat Ridge Renewable Energy Facility 3, and the purple fingerling polygon represents the Wheat Ridge Renewable Energy Facility 1. Wheat Ridge Renewable Energy Facility 2 is south and is this red polygon as well. And here to the upper left is the Carty facility, and in red is Carty coal plant. And unless anyone's got any questions, I'm going to move on to my next project update.
Madam Chair, this is Hanley. Chase.
Go ahead, Hanley.
The 8-mile transmission line, is that shared with the wind project?
I would have to look back at the NOI. I don't know off the top of my head, and maybe Sarah, if she's on the meeting right now, would know. Otherwise, I can loop back around with that answer.
I mean, we have so many. I mean, we have other solar, lots of wind, all together here, and I didn't know whether they were developing a brand new 8-mile transmission line just for this solar, or that'd be interesting to know.
I can look into it, Councilmember Jenkins, and get back to you with a response later in the day.
Sure, thank you.
Okay, unless there's any other questions, I will move to my next. My next project update is for the Boardman Solar Energy Facility request for Amendment 1. The approved facility, Boardman Solar Energy Facility, is not yet constructed, and it's a 75 megawatt solar photovoltaic power generating facility located within a site boundary of approximately 798 acres. The site certificate holder is Boardman Solar Energy LLC, a subsidiary of Invenergy LLC. And as far as location is concerned, the solar energy generation components of the facility will be located in Morrow County. However, the 115 kilovolt transmission line that would connect the energy facility to the grid will be located entirely within Gillum County. So the facility is located in both counties. However, the only component within Gillum County would be the transmission line. And here we go. With regards to Amendment 1, on August 4th of this year, the department received a complete request for Amendment 1 of the Boardman Solar Energy Facility. And request for Amendment 1 seeks council's approval for a 3-year extension to both the construction commencement and completion deadlines. The construction commencement deadline would be extended from February 23rd, 2021, so earlier this year, to February 23rd, 2024. And the new construction completion deadline would be extended to February 23rd, 2027. As Secretary Cornett mentioned during his secretary report earlier today, on August 12th, the department determined that a Type B review for request for Amendment 1 was justified based on review of the Type B ADR, or Amendment Determination Request provided. Concurrent with the Type B ADR determination justification, the department also issued its draft proposed order on request for Amendment 1 on August 12th. And the issuance of the draft proposed order began a 25-day comment period on the DPO and complete request for Amendment 1. And the comment deadline for comments on the DPO and request in the complete RFA is September 6th, 2021. And here is just a figure of the proposed facility, or of the approved facilities site boundary. And so it's this pink polygon just directly beneath or south of I-84. And this tail of a line is the transmission line, the sole component within Gillum County. Everything else is in Morrow County. On to the next. My last and final project update of the day is for the State Line Wind project. The State Line Wind facility is an operational wind energy facility consisting of 2 units, State Line 1 and 2, and Van Sickle 2. State Line 1 and 2 is composed of 186 wind turbines and has a peak generating capacity of up to 123 megawatts, whereas Van Sickle 2 consists of 43 wind turbines with a peak generating capacity of 99 megawatts. The site certificate holder is FPL Energy Van Sickle LLC for State Line 1 and 2, and FPL Energy State Line 2 Incorporated for Van Sickle 2, which are both subsidiaries of NextEra Energy Resources LLC. The facility is located in Umatilla County, entirely on private land, north and east of the city of Helix. And as far as procedural history is concerned, the approved facility on May 17th, 2019, Council approved a 5th amended site certificate, which authorized the certificate holder to repower existing wind turbine blades in the cells for the operating Van Sickle 2 unit, and the certificate holder must initiate construction by 2022. Let's go on to what the request for Amendment 6 is requesting and seeking. On July 12th, 2021, the department received a preliminary request for Amendment 6 to the State Line Wind Project Facility Site Certificate. And the preliminary request for amendment requests two primary changes. The first is to add 50 megawatts of battery storage on approximately 11 acres. And the second is to amend the approved turbine specifications, including megawatt output, number of turbines, and associated development improvements of the Van Sickle 2 unit in consideration of the approved repowering from Amendment 5. And there's 3 options proposed in request for Amendment 6 for this repowering turbine specifications. Option 1 is to repower all existing turbines from 2.3 megawatts to 2.66 megawatts. And to do so, each turbine would be increased from a total height of 440 feet to 489 feet. And the above ground blade tip clearance would be reduced from 85 feet down to 59 feet. And these total height and above ground blade tip clearance are both respectively the tallest and closest of all options provided. So the 489 feet is the tallest of all 3 options, whereas the 59 feet would be the least amount of blade tip clearance of the 3 options proposed. Option 2 would be to replace 3 turbines and changing them from 2.3 megawatts to 2.32 megawatts. And that would increase the total turbine height from 440 feet to 452 feet. And it would reduce the minimum ground blade tip clearance from 85 feet to 72 feet. And the remaining 40 turbines would be repowered consistent with option 1. And lastly, option 3 as proposed would add 2 additional turbines consistent with option 1, as well as converting 1 existing turbine from a 2.3 megawatt turbine to a 2.32 megawatt turbine. And that would increase, much like option number 2, the total height from 440 feet to 452 feet and reduce the minimum ground blade tip clearance from 85 feet to 72 feet. And the remaining turbines with option 3 would be repowered with repowered consistent with the turbine specifications of option number 1. So in short, option 1 lays out the turbine specifications and the total height of 489. Option 2 would replace, and that would replace all, or repower. Option 1 would repower all of the turbines. Option 2 would repower 40 of them with the option 1 specifications, and then repower 3 with less height. And option 3 would actually add 2 turbines consistent with option 1, and 42 of them would also be repowered consistent with option 1, and 1 would be minimally repowered to the specifications of option 2. And we did receive a Type B ADR review request with this facility. And here is a figure for location, project location. As mentioned, the State Line Wind project is located entirely in Umatilla County and entirely on private land, and is located both north and east of the city of Helix. And it's just south of the Oregon-Washington state line border. And with that, I conclude my project updates, but if I definitely welcome any questions, if there are any questions by council. And
Does anyone have any?
Chair Grill, Chase, I've got a question.
Yes, Cindy.
So with the request for amendment and the 3 options, so is the department, are you evaluating all of the different options? What's the applicant asking for? A review of all of the alternatives and an approval no matter what they choose, or does the department determine which is best, second and third?
No, we would be reviewing all 3 options and making findings on all 3. Yeah.
Okay. All right. Thank you.
Madam Chair, this is Hanley.
Go ahead, Hanley.
Chase, where would the battery storage be? Didn't you say there was going to be 50 megawatts of battery storage added?
Yes, and the battery storage, let me see if I can do this. There's a good figure. Battery storage. Sorry, Hanley.
Well, the reason I asked the question is they've asked for a Type B evaluation, but if the battery storage is going to change the site boundary, we probably should be aware of that. I mean, if it's within the existing site boundary, I think that's one thing, but
so let me see if I can pull this onto the screen. Are you able to see this PDF figure?
Yes.
Okay, so this is what they provided in their NOI, and this is a figure of the battery storage. And here, this is the detailed area. It does appear that the battery storage itself would be centrally located within the existing approved site boundary. I don't know if you can see that reference. It might be way small. Let me zoom in. So here's the reference map. But something to definitely consider and take into account. Thank you, Councilmember Jenkins. And my colleague Katie Clifford, she did let me know that for the Wagon Trail solar, the 8 miles of transmission line would be new overhead 230 transmission line. And it would connect to the existing Blue Ridge substation. So that was in response to your earlier question, Councilmember Jenkins, on whether or not it would be utilizing existing transmission or not. It wouldn't be as proposed, and that's Wagon Trail.
Okay, and so for the battery storage on State Line, I assume they're going to have to, they just can't, they're going to have to establish some kind of a foundation for those battery storage facilities. Is that correct? It looks like a new access road's going to have to be built, and some kind of foundation, whether it's concrete or gravel.
I would imagine so, yeah.
Okay.
We can, well, yeah, battery containers and inverter skids would either be placed on an engineered grade or a poured concrete foundation, or utilize steel piles depending on site conditions in Umatilla County, is what they say here.
Okay. So the request is for a type B.
Correct.
But you haven't given there isn't a department evaluation on that yet. Is that correct?
We haven't issued our determination. That's correct.
Okay.
We did recently determine that their RFA was incomplete, and we issued requests for additional information for this particular amendment. So,
okay. Thank you.
I guess I would just add, Councilmember Jenkins, that for these requests for review under the Type B process, that we've been trying to wait till we're closer with the draft proposed order so that we have a better handle on, whether there are new or amended conditions, the significance of the issue. And I think that served us well, rather than issuing the Type B review determination just, earlier, before we've had a chance to coordinate with all the reviewing agencies and do that initial analysis. So we're expecting that to come out in about a month after they respond to our information request.
Thank you.
Chase, you're on mute.
thank you. With that, I am going to conclude my project updates unless there's any additional questions.
Anyone have anything else? Hearing nothing, then we'll move on to the next agenda item. Thank you, Wally, Chase, and Katie, for your presentation today. The next agenda item E, is the public comment period. This time is reserved for the public to address the council regarding any item within council jurisdiction that is not otherwise closed for comment, which includes the Boardman to Hemingway transmission line proposed order and the Obsidian Solar Center proposed order, both of which are in the contested case process. I will look to Donita to see if we have anyone wishing to comment.
At this time, I'm
Donita?
seeing no hands. I was waiting to see if anybody had a chance to get their hands raised, but anybody that's calling in that they're not aware, press *3 on your phones to raise your hands. And people attending the webinar, hover over your name and click the little hand icon to raise your hand. Irene Gilbert would like to make comment.
Thank you. Ms. Gilbert, the floor is yours. Please go ahead. Ms. Gilbert, do you have your mute button on?
Do I have my mute? Now I'm okay? Okay. Anyway, thank you for allowing me to speak today. I just wanted to make a couple of comments about the process that you folks use when you're addressing, I guess, appeals for different decisions that the council makes. And the first one being that 3 minutes is not a lot of time for anybody to present information about anything. So I'm not surprised that Mr. McAllister did not choose to speak to the council directly. The second one would be that I'm just concerned that when you address issues that people bring in and you break them up into isolated areas, when one of the issues is a ongoing, I guess, demonstration of problems, you really need to look at the cumulative effect of those decisions. And so I guess those are the main things that I wanted to say. And I am submitting to the record for the case that you just heard, the written comment, or pardon me, the verbal comments that I had intended to make, and have asked that those be provided to you folks. I realize you've already made the decision, but I think you need to understand the limitations that you're placing on people and the fact that you're, as a result, making decisions absent the full story. So that's what I wanted to say. Thank you.
Thank you, Ms. Gilbert. Do we have anyone else wishing to make public comment?
Not at this time, Madam Chair.
Thank you. Well, with that, then the public comment period is closed at 11:54. And our next agenda item is well, it's not an agenda item, but our next item is for us to take a lunch break. Council members, would 15 minutes suffice, or do you need more time?
About 20.
All right. Well,
You
we
can
will
do
go
it.
with 20 minutes. So how about if we get back here, let's come back at 12:15. That'll give you 21 minutes, Hanley.
Thank you.
Thank you. Thank you, everyone.
Thank you.
I guess everyone's made it back. Let's see. Yep, I see bodies. Okay.
I'm here.
So the next item, I'm sorry.
This is Hanley. I'm here.
Yep. I hear you. Thank you. So the next item is agenda item F, and that is the retirement and financial assurance standard overview. This is an information item. Sarah Esterson, Odo Senior Policy Advisor, and Chase McVeigh Walker, Odo Senior Siting Analyst, will provide an overview of the retirement and financial assurance standard. Sarah and Chase, the floor is yours.
Thank you, Chair Grail. Sweet. Just a few seconds while I get set up. Donita, can you give me share rights or pass the ball? Okay, am I sharing the right screen or not?
Yes, you are.
Yeah?
Yeah.
Okay, you can see my cover. Okay, great. All right, great. Thank you so much. Good afternoon, Chair Grail, Vice Chair Howe, and members of the council. For the record, my name is Sarah Esterson. I'm the Senior Policy Advisor with the Oregon Department of Energy Siting Division. And as Chair Grail noted, Chase McVeigh Walker, our Senior Siting Analyst, is also here with me today. And together we'll be presenting agenda item F, which is an informational item for council, which is focusing on your retirement and financial assurance standard. And our rule is at OAR 345-022-0050. So just a brief overview before we launch into this, that our presentation will describe the purpose and intent of the standard. We'll give you a little bit of an overview of the regulatory history, where and when did this standard come from. We'll address both the substantive and informational requirements, and then we'll talk about application of and the compliance obligation of the standard throughout the siting process. The goals of our presentation today are to ensure that council has a clear understanding of the standard and the information requirements that an applicant is required to provide in an application or an amendment request, and then to initiate and foster deliberation on potential improvements. Please. Yes, I'm so sorry. And then to foster a discussion about improvements that we can make, either big picture, you know, at a policy level or through rulemaking, or smaller adjustments that can be made, such as the information we might request of an applicant through review of a preliminary application and the evidence that we rely upon. So hopefully we'll give you an opportunity to think about that. Okay. So first, let's make sure that we understand what the language of the standard says. The Retirement and Financial Assurance Standard requires council to make findings and conclusions of law under two provisions. First, you have to find that the site of the facility can be restored adequately to a useful non-hazardous condition following permanent cessation of construction or operation. And then two, that an applicant has a reasonable likelihood of obtaining a bond or letter of credit in a form and in an amount satisfactory to council to restore the site to a useful non-hazardous condition. So I just wanted to highlight two things about this language. So note under sub 1 here that it says, it uses a phrase useful non-hazardous, and that is a phrase that is not specifically defined. And maybe, you know, non-hazardous is more straightforward. You might think, of course, you know, you have to leave the site uncontaminated, but more focusing here on the term useful, and based on, you know, what does useful mean? Does it mean pre-disturbance condition? I don't think so. Based on past council decisions, the term useful has allowed for consideration of maintaining some facility components, such as a road, as part of decommissioning. And then another interesting component of this language would be on subpart 2 here, where it requires that the council find that an applicant has a reasonable likelihood of obtaining a bond or letter of credit in a form and amount satisfactory to council. Maybe you are fully aware, but we, council and the department, have interpreted form to be specific to the template of a bond or letter of credit that's used as part of the bond or letter of credit that would be submitted to meet the retirement and financial assurance standard after approval. And then it's the way that the form, based on a template approved by council, is incorporated into the requirement is through the site certificate condition. So just wanted to highlight that. Okay.
Sarah, Sarah, this is Hanley.
Yes.
Madam Chair, may I? Can we go back to number 1?
Yeah.
So the term useful, we ran across this in county land use, where a project is returned to a use that is does that use have to be a use that's authorized within the zone?
Yes. Well, I think.
Is that implied in the term useful?
Yes, I think that has been the historic interpretation, that it is consistent with allowable uses within the zone, consistent with the surrounding landscape, and consistent with whatever the landowner might be willing to maintain. Or again, like a road is an easier example.
Right. Okay,
But,
thank you.
Yeah. I think, you know, just to maybe put another example in there, we evaluated this question pretty thoroughly for the Columbia ethanol facility, where they had asked for council to evaluate whether maintaining industrial infrastructure once cleaned at the site within the industrial zone could be interpreted to be useful. And in that situation, council found that because the Port of Morrow was willing to sign and provide an executed memorandum of agreement, that they believed, Port of Morrow being the underlying owner of the land that the facility was on, that they would in fact find that industrial equipment useful at the site once cleaned. The council found that that met the intent of the term.
Yeah, that's a great example.
Yeah, Sarah, let me jump in. So for the record, Todd Cornett, you know, most of the facilities that the council reviews are on exclusive farm use owned land. And so a typical example, you know, Sarah had mentioned, you know, maybe retention of roads, that could be fine because that could be valuable to a farm operation, but that would be a site specific evaluation. Typically, whether it's, you know, underground lines, pipelines, you know, electrical lines, foundations, those all would need to be removed to, you know, at least 3 feet below ground, so that the area could be then, you know, covered in topsoil and cropped again. So that would be an example of, they don't have to permanently, you know, remove all, so the foundations for every wind turbine, but they would do it to a level that then could return the site to crop production. So that's sort of the level, you know, and Sarah brought up a good example within the industrial zone. You know, we and you as council are going to look at each location differently and to figure out what that reasonable conclusion is to determine what is sort of useful, non-hazardous for that specific site.
Okay, thank you for the input and the questions. Sorry. Okay, so we just wanted to highlight the purpose of the standard, which I think is fairly straightforward given the language of the standard. It doesn't differ that significantly. But just to highlight for you that the purpose of the standard is to ensure that an applicant or certificate holder has an ability to decommission and restore the facility site consistent with the zone, the landscape, and landowner input. as you know, as similar to what we've just gone through, but most wind and solar facilities in particular are on land that's being leased from an underlying, what we might call participating landowner, so that their input can be considered at decommissioning and that final decommissioning plan. A secondary purpose of the standard, which is one that we find and council's found very important, is to provide protection to the state of Oregon if the certificate holder becomes unable to decommission the facility site on their own. That's where we move into requiring an applicant to, once approved, when they become the certificate holder, submit a bond or letter of credit in the amount and the form satisfactory to council prior to moving forward with construction. So the council looks at the ability of the applicant to obtain a bond that demonstrates some level of financial security. Then once approved, they have an ongoing requirement to maintain the bond. And then if it were to fall apart because we have that bond in place and they provide it to the department, that we're then protected as the holder of that financial instrument. So the evaluation of whether the applicant has the ability to decommission and restore the site is based on information requirements in Division 21. And it starts with a decommissioning estimate, where the adequacy of that estimate is based on tasks and actions needed to restore the site and decommission the facility. And then the validity and adequacy of the assumptions and data sources that go into that estimate. We also evaluate whether they have any decommissioning experience or have demonstrated an ability to hire adequate contractors to do that activity. We look at their ability to obtain a bond or letter of credit. And then we have this, it's a legally binding requirement we'll talk about here in a slide or two, across mandatory conditions as well as individual conditions, that a certificate holder have a bond or letter of credit using a financial institution, which is mostly AAA rated institutions and pre-approved by council, that we have that in place prior to construction. Okay, so just a little bit of an overview of where this standard came from. So the standard originated at the same time that the council was established in 1975, where the legislature gave council the authority to adopt standards specifically addressing the financial ability and qualifications of an applicant to construct and operate an energy facility. And then it was in the 80s when council started to adopt standards from statute. And I think in the beginning, they were specific to types of energy facilities rather than one wholesale standard like we have now. And then it was in the 90s we started to look at the ability of the applicant to obtain a bond or letter of credit. And then through the 90s, we came into 2002, which is where all of the previous energy type specific standards were consolidated into one, which represents the standard that we have today. And so, as I understand it, the standard hasn't been modified since 2002. Okay. So I think I just wanted to take the time to make sure everyone understands the crossover and importance of some standards and our Division 21 requirements, because it's all, not everything is interrelated with everything else, but there's a lot of information across our 30 exhibits that can feed into the evaluation of the retirement and financial assurance standard. So again, just making sure council understands that an application for site certificate has to contain exhibits, and they're called exhibits A through CC. That's 30 exhibits. Those exhibits have to have information that aligns with the information requirements in OAR Chapter 345, Division 21, and it's extensive. And this is the information that has been established as that should inform the evaluation of compliance with Council's 12 primary standards, which apply to all FSIC jurisdictional energy facilities. Then of course, there's many other requirements beyond those 12 primary standards, but we'll just stick with that for now. So for the retirement and financial assurance standard, there is a specific crossover with the organizational expertise standard and with conditions that are referred to as mandatory conditions. And those are in Rule and Division 25. Mandatory conditions apply and must be included in every site certificate for every certificate holder. So just to highlight, you might be familiar, but in the organizational expertise standard, council has to make findings about an applicant's ability to retire the facility and their represented experience in retiring the facility, and that they have to have a demonstrated ability to restore the site to a useful non-hazardous condition. So clearly, those are some of the same requirements under retirement and financial assurance. And so we look at some of that information that feeds into the organizational expertise, any of their experience, and again, you know, what they provide in narrative about their ability to hire qualified contractors. And then just for your reference, so our mandatory conditions, I think we've pulled 4 here that have crossover with retirement and financial assurance and kind of give us more a very strong regulatory hook to protection under the standard. So we have a mandatory condition that requires that they submit a bond or a letter of credit, a mandatory condition that requires that they, upon decommissioning within 2 years, I believe, submit to council for approval a final retirement plan, and then they have to follow that retirement plan as they go through decommissioning in order to terminate their site certificate. And then there's one last condition that if for some reason they aren't able to come forward with a retirement plan, that gives the mandatory condition gives council the authority to create and impose one on their own. Okay, so now I think we're going to try to do something that is, I hope, isn't overly complicated, but Chase is going to explain the information requirements of exhibits W and M, which both feed into the retirement and financial assurance standard, and give you some context by helping you review briefly specific examples from the last application that this council approved. So give me 1 second and I will try to give it over to Chase.
Okay, there we go. Let's see.
Did I do it? Okay. Thank you.
Okay. First, can everyone hear me and also see my screen? Okay,
yes.
Good. Thank you. Thank you, Sarah, and good afternoon, Madam Chair Grail, Vice Chair Howe, and members of the council. Again, for the record, my name is Chase McVeigh Walker, a senior siting analyst with the siting division at the department. For the next couple slides, I will try to provide an overview of the Division 21 requirements for both Exhibit M, financial analysis, and Exhibit W, site restoration. And I'll start with the informational requirements of Exhibit W, which are here before you on your screen. The information provided in Exhibit W provides an overview of the decommissioning and site restoration activities that will be taken at the end of the facility's useful life and an estimate of their costs. While the rules do not include detailed requirements, the information must be specific enough to validate the decommissioning bond or letter of credit amount proposed in Exhibit M. Exhibit W must include information about site restoration including these 5 bullets, which is the estimated useful life of the proposed facility, specific actions and tasks to restore the site to a useful non-hazardous condition, an estimate in current dollars of the total and unit costs of restoring the site to a useful non-hazardous condition, a discussion and justification of the methods and assumptions used to estimate site restoration costs, and lastly, for facilities that might produce site contamination by hazardous materials, a proposed monitoring plan such as periodic environmental site assessment and reporting, or an explanation why a monitoring plan is unnecessary. And now I'm going to try and do something a little bit tricky and show, let me end this slideshow. Are you still able to see my screen? Okay, and so what you should see before you is half and half. I have the current slide that I was just talking about with the information requirements from Exhibit W on the left, and on the right, I have Exhibit W as provided by the applicant at the time, now certificate holder, for the Madras Solar Energy Facility. And so this is the complete Exhibit W provided in the complete application for site certificate. And so I'll just thumb through these 8 pages to show you what was provided. And let me see. Oops. So to begin with, the applicant at the time in Exhibit W provided an estimated useful life for the facility, and for Madras specifically, they estimated the useful life to be 40 years. And then they caveat and say, however, it may operate for as long as there is a market for the production of electrical energy. And I did look up what was provided or provided as an estimate for useful life originally for the Montague wind power facility. And in 2010, when it was originally approved, the estimated useful life was 25 to 30 years. So, I mean, I know that's a wind facility and this is a solar facility, but there is a range in what we're receiving as far as an estimate to useful life is concerned. So that's just information. Next, we roll into the narrative the applicant provides for retirement and restoration actions. And there isn't actually like a set methodology that they have to follow. It's whatever they provide and we evaluate. And here it was just narrative on the restoration actions, which then flow into their discussion and justification of the methods and assumptions used to formulate their cost estimate table, which is at the end of this exhibit. And we check and see if there's we check their in-text citations and links provided to validate what they're saying. We also look back through the 29 other exhibits to check and make sure that total tons match up to what is represented in Exhibit B, or water usage. We look at water, and we do thumb through the rest of the exhibits to make sure that what's represented here and their justifications and methods and tasks are accurate and consistent. And so here for Madras, as far as the monitoring plan is concerned, they indicate that it's not expected to cause site contamination, and they provided a reason with why it's not expected. And at the tail end of the exhibit, in Exhibit W, we have their cost estimate table. And here they actually provided two cost estimate tables, one where battery storage was incorporated in and one where battery storage wasn't. And this first table is the example where battery storage wasn't incorporated in. And what we do look at is the units used and the quantities and the cost per unit. We do compare that to other data sources and other cost estimates. And something that I constructed myself a couple years ago when I was trying to validate cost estimates for particular facilities was a Excel spreadsheet where I looked at different approved and proposed facilities. And specifically here, we have a couple wind and natural gas. And I wanted, what I was trying to do was compare the cost per acre of disturbance from different generating sources, because I was interested in seeing how it lined up and if there was a way to correlate cost per acre to new facilities and validate their cost estimates. And I also looked at costs per megawatt generated. And what I've found, and I apologize, it hasn't been expanded since, but what I found was that solar in general on a cost per acre of disturbance ranges, or usually falls in the range of like $7,000 to $10,000 is where we usually end up. And these were all three of these bottom rows were for the Boardman Solar Energy Facility in the original application, but this first one was our department's consultant's estimate. This was what was provided by the applicant when they followed the cost estimate guide the department had for wind, and this is ultimately the breakdown from the final order. But like for Madras, for example, I did look at, and I don't have the number, I apologize, but I looked at what this total amount was, or subtotal was, and I divided that by disturbance acreage, and I got in that $7,000 to $10,000 range. And so that, amongst other things, is one way that I have been comparing facilities and validating validating the estimates.
Mm-hmm. And maybe just to tee off that a little bit. So if everyone remembers that this is one of the findings the council has to make, that the amount for the decommissioning is satisfactory to council. And so we do spend a fair amount of time trying to make sure that the amount is adequate and as close to accurate as possible without having a set methodology. And so some examples I think Chase was trying to point out, you know, Exhibit B is a description of the facility and a description of the structures and systems. And when we look at that, we can say, okay, well, you have foundations, you have access roads, and we can cross-check all of that information with whether it is reflected in the estimate. Similarly, we have Exhibit G, which is a materials analysis, and they're supposed to provide the types of materials and quantities that they would need for construction, operation, and decommissioning. So we can cross through that and kind of look through and make sure, at least based on what they're representing the facility is, that they haven't missed anything based on their description of the facility. And that's, you know, we use the existing exhibits to kind of provide some level of a verification, and then we dive into the details about the adequacy of the assumptions and the inputs, which oftentimes, you know, they're using a source of US labor rates to get labor rates or equipment rates, and we can kind of, again, fact check those inputs, but a lot of times the methods differ And so we have to do quite a bit of back and forth with an applicant to make sure that we understand where they got a hard number, if that's what's being given. But we also try to balance that with the overall total of the amount, and try not to get overly critical of every single detail, but so it's a balance. And yeah, so back to you, Chase.
Thank you, Sarah. Okay. Next is my informational, there's a slide for the informational requirements for Exhibit M. And Exhibit M must include information about the applicant's financial capability, including an opinion or opinions from legal counsel stating that, to counsel's best knowledge, the applicant has the legal authority to construct and operate the facility without violating its bond, indenture provisions, articles of incorporation, common stock covenants, or similar agreements. The type and amount of the applicant's proposed bond or letter of credit to meet the requirements of the Retirement Financial Assurance Standard. Additionally, Exhibit M includes an informational requirement to the applicant, or for the applicant to provide evidence that they have a reasonable likelihood of obtaining a proposed bond or letter of credit in the amount proposed in paragraph, or as in an amount to restore the facility to useful non-hazardous condition before beginning construction of the facility, and the type and amount, for facility decommissioning. And most applicants satisfy these requirements by providing a comfort letter from a financial institution on council's pre-approved financial institution list. And the comfort letter usually states that they're willing to, the financial institution is willing to provide the necessary bond or letter of credit. And as I did for Exhibit W, I'm going to do a split. Let's see. And look at what was provided for the Madras facility most recently. And here is just a brief explanation of what else is in this exhibit and how they meet each of these requirements. And we roll right into their legal opinion letter. And so we look at where it came from and what's represented in it. Next, so that looked great. Stoll Reeves wrote this letter. And let's see, going on to the comfort letter from the bank. So the Hanover Insurance Group wrote this comfort letter, and prior, if I remember correctly, prior to the Madras facility, the Hanover Insurance Group wasn't on council's pre-approved list, but prior to issuance of the DPO, they were added, and there was an evaluation, and there was a process to add them to council's list, and so they are on the list. And let's see, I think that might be all that I want to share with this exhibit. So and Sarah, please take the mic if you have anything else.
Yeah, other than just kind of restating that Exhibit M is supposed to be information about the applicant's financial capability. And this, what Chase just walked through is exactly meeting the language of Division 21 about their financial capability. So if there's you know, if there's anything to be looked at, if there's concerns about level of evidence or information to evaluate their financial capability, you know, this is our foundation that it's currently based on. Okay.
All right, and
Sorry, I'm not sure if anybody can see me raising my hand.
Sorry, go ahead, Cindy.
Sorry, thanks, Chair Grail. Chase and Sarah, just a follow up on this, and thank you. I find this very helpful. When preparing for today's meeting, I looked at some of these exhibits for others and found them somewhat lacking in the letters from both the surety and the law firm. It really narrowing their liability and what they were, what I thought they were attesting to. Like one was a surety, an insurance company saying, yes, this is a valued client, and I'm paraphrasing, and we'll be able to get, I'm sure they'll be able to get a bond from someone. And quite frankly, I think it was Obsidian's application that I was looking at, which I found somewhat inadequate. That someone who has a relationship, who may be being paid, says, yes, I'm sure they'll be able to get a surety from someone, a bond from someone. And then the letter from the law firm did not include the bond provision that they would be able to meet the bond provision. It was specifically excluded from the language, and at the end of the letter narrowed it to, this is this attorney who's making this declaration or whatever, not the law firm. And so I wondered how you, you know, how you analyze those in terms of, you know, the time between, I guess, when they apply for a site certificate or granted it and they are able to get the bond, and then further, given the letter from the law firm, for the next 30 years. You know, because the law firm is attesting, you've got the bond, so the surety is taken care of, but the law firm is saying, yes, they have the ability to do this project for 30 years, for a 30-year life. And so I'm just wondering how you assess those, or say, yep, check, we've got the documentation.
Yeah. I mean, I guess it goes back to like this, like how we look at the words of the standard that say you have to find that an applicant has a reasonable likelihood of obtaining a bond. And then again, like offset with the fact that they have to have a bond in order to go forward, so that we look at the condition together, like, because the standard doesn't require that they give us a bond as part of the application. And so, I mean, I think what you're asking is the evidence we're looking at sufficient to answer the question of whether they have a reasonable likelihood of obtaining a bond? Now, but now to go to the opinion of legal counsel and how, you know, what weight that might have for a 30-year cycle, well, I think that question is answered with the fact that that legal opinion is no longer needed once they get approval. If you found that legal opinion to be valid for the time frame you're looking at, because then we then have to have the bond.
So let me,
Yeah,
let me jump in. Sorry, just let me jump in real quick. So for the record, Todd Cornett, looking at the Exhibit M, it's an opinion or opinions from legal counsel stating that, to counsel's best knowledge, the applicant has the legal authority to construct and operate the facility without violating its bond indenture provisions, articles of incorporation, common stock covenants, or similar agreements. So they're doing a legal assessment, not, is this a viable, developer who's going to be able to build, own, and operate the facility for 30 years without a problem. They're doing a legal analysis, is do they have the legal ability to do that? Or is it in violation of any of these provisions, again, in bond indenture provisions, articles of incorporation, common stock covenants, or similar agreements? So they're at that point saying at the very beginning that they're doing a legal analysis of the developer's ability to do it, not necessarily, looking out 30 years into the future and sort of validating whether or not there's going to be any potential problems or not. So it is at a point in time saying, can they legally do this? And at least that's how my reading of that Exhibit M sub A requirement is.
Okay. I guess maybe I'm struggling with the point in time and the decision we make for 30 years, but maybe it's because I haven't done it. So, I mean, I don't have that tenure, but okay, thanks. I may follow up with that.
Yeah, and just again, the whole point of this is to, one, convey what these standards are so that, council members are clear, but, to seek, are we doing it, in the way that the council wants us to? Some of these can be pretty clear and objective, and some of them are fairly broad and allow for varying interpretations. And so that's exactly what we want to do, is have this kind of conversation. So, council members are concerned with what we're relying upon as evidence in terms of our recommendations to you. And there is that room for interpretation. We want to hear what those issues and concerns are.
Okay, thank you.
Yeah. I mean, I certainly would be interested in your feedback as we, I think Chris will start talking about the rulemaking where we're looking at our standards. But if there's a way that sub A could be, how can we really evaluate whether that's giving us what we need to evaluate their financial capability if in fact it's lacking. I'm not sure if the lacking that you saw with Obsidian was lacking within the framework of the sub A, or like sub A is lacking, but either way, I think we should look at it.
Yeah, and I don't want to say that it was necessarily lacking, but in my reading of it, it did not give me comfort, I guess. And it's often referred to as a comfort letter or whatever. I thought, ooh, this is very, very limited. But they would get the bond in the end, so maybe it doesn't matter. But if we have it on the front end, I'd like it to give more comfort. I guess that's what I was thinking. So.
Absolutely. Well, and I think that's where we're really trying to get. If the information is required in an exhibit for our evaluation, we want it to have value and be the information that's needed to support an efficient process. And if we have information that doesn't give much weight to the analysis, then what value is it serving? And so, I mean, we definitely want to go there.
Okay, thank you.
Patrick Rowe with DOJ. I have just one quick comment, Councilmember Condon, with regard to the concern you expressed about the fact that one of the legal opinion letters you saw limited the opinion to coming from one attorney at the firm. I don't find that problematic. Our standard doesn't require that the opinion letter come from a firm. We would certainly accept an opinion letter from a solo practitioner if they were qualified in this arena. So that doesn't cause me concern.
And just to respond, and I appreciate that fully. I just looked at it as, here's a firm, it's on the firm's letterhead, and then narrowing to, this isn't our opinion, it is the attorney. Actually, they named two attorneys. And I apologize, I think it was Obsidian, but I looked at a couple of them. And so I don't want to put out there that anybody was lacking. I should have said X, but anyway, I mean, I'll just pursue that a little further. in another forum. Thanks.
Hey, Sarah, I see that Chris has his hand up, so you may want to go to him if he wants to add
Yeah.
something.
Go for it, Chris.
Thanks, Sarah, and Chair Garrell, Councilmember Condon. I just wanted to add real quick that it's a kind of a note, but that paragraph A was added when the standard was really related to financial capability, which was like more related to, there's the organizational expertise, which is more of a technical expertise standard. And then there was this financial capability standard, which was really about, do they have the resources to successfully construct, operate, and retire the facility? And at that time, there wasn't actually a bonding requirement. And so that might be part of the mismatch of like why that legal opinion letter does not provide necessarily the same information that we would need to determine that somebody could actually get a bond or letter of credit.
That helps me.
Thank you, Chris.
Yeah. Great. Well, thank you so much for the discussion. That was great. So, Lisa, are you concluded?
I am concluded. I can pass you back the ball.
Sure, if you are able to do that.
So Sarah, are we finished with this item or do you have more?
Just about. We're just about.
Just checking, making sure.
Yeah,
I'm not
no
missing
problem.
anything.
No problem. Okay. Am I sharing? Can you see the? I'm sorry, I've lost what screen. Am I sharing the presentation?
No, not yet. We have a couple of boxes up that are partial, but not the PowerPoint presentation.
I can continue through if that's easy.
Okay.
If you want to pass me back the ball.
Sure. Sorry, everyone. I do apologize. Okay. Thank you, Chase.
Yeah.
Okay, so just to wrap up here, we thought it was valuable to highlight for council the kind of the shift over time for an applicant as they become a certificate holder and the applicability and or compliance with the standard. So what we've really been focusing on here so far is kind of maybe obviously what goes into the evaluation of compliance for council to make a finding that an applicant can satisfy the requirements. And that starts, again, just in summary, like they have to have an adequate, satisfactory estimate for decommissioning and restoring the site of the facility and sufficient evidence to demonstrate that they can obtain a bond or a letter of credit in this form and amount deemed appropriate by council. Then, if approved by meeting all council standards and an applicant becomes a certificate holder, then they have numerous conditions imposed under the retirement and financial assurance standard, as well as the mandatory conditions that we talked about. And then before a certificate holder can start construction of the facility, amongst numerous other requirements, they have to submit a decommissioning estimate for the facility based on final design. So as we've seen in practice, certificate holders are getting approval for, in large part, a much larger facility than what actually goes forward. So that, and the conditions allow them to take what was a full build out decommissioning estimate and adjust that based on final design. Now they can't adjust the unit costs or the tasks and actions that were approved, but if they don't build the full 100 wind turbines when they only have 51, or 2 substations when they only have 1, they can adjust that sort of the quantity of facility components. And that's the only adjustment that can be done in addition to an inflation adjustment. So if their decommissioning estimate was approved in 2020, but they don't build until 2025, we go through that exercise, and it is part of the condition of the process for inflating based on GDP indicator index, that final estimate. So we go through the process of pre-construction of reviewing and evaluating and validating that estimate. Then we get the bond and the most current bond or letter of credit and the most current template that council has approved from a financial institution that council has approved, and then that goes into our lockbox. And then once they move into operation, they're on an annual cycle where they have to update that bond or letter of credit based on inflation. And our fiscal analyst, Cicely Fleming, sort of manages that and makes sure letters are sent out on the same cycle as their bond or letter of credit cycle so that we get those annually. And then when and if we have an FSEC facility that it falls under our decommissioning and site certificate termination rules, then they have to go through this process of submitting a decommissioning plan to council for approval, and then following the requirements of that decommissioning plan to then close out the site certificate. And that scenario would be one where we never had to exercise the bond or letter of credit, but of course that bond or letter of credit that we've kept track of the whole time gives the state that protection in case the certificate holder were to have issues in fulfilling that obligation. So I believe that is the conclusion of our slide deck. And so if there's any other questions we can answer at this time, we'd be happy to. Okay, well, we really appreciate your time and interest, and I believe I might have failed to mention this in the beginning, but this is part 1 of 2, and so we will be following up at the next council meeting, likely with some additional information and examples and ideas.
Thank you, Sarah.
Thank you,
Chase.
Yeah. Now.
All right. Well, next up is agenda item G, the surety bond template update. This is an action item. We have Christopher Clark, ODA Rules Coordinator, who will provide recommended template language updates for surety bonds. Christopher, the floor is yours.
Thank you, Chair Grail, members of the council. For the record, my name is Christopher Clark. I'm a citing policy analyst with the department and the council's rules coordinator. I'm going to be actually with you for the next 3 agenda items. So I'm going to do my best to keep things moving along as best I can. But please do interrupt me if you have any questions, because I may miss raised hands or that sort of thing. So as Chair Grail just mentioned, the first item I'm presenting is a follow-up on our last agenda item. I'm going to be giving an update on the council's financial assurance instrument templates and providing staff's recommended changes to the surety bond template. And you all can see my screen okay? I'm imagining. Yes, excellent. Okay.
Yep.
Thank you. Okay, so Sarah just covered a lot of this, but the council's rules by the Financial Assurance and Retirement Standard requires each certificate holder to provide a bond or letter of credit in a form and amount satisfactory to the council to restore the site prior to, and they submit that prior to beginning construction of the facility. The bond or letter of credit provides assurance that the certificate holder will restore the site to a useful non-hazardous condition at the end of the facility's life. And then, as Sarah just mentioned, that bond or letter of credit must be kept active until the facility has been retired. And Sarah explained the process for adjusting the amount for inflation. So the council currently has about $168.2 million of financial assurance on file. Around 56% of that, which is around 94.2 million, is provided in letters of credit, and the remaining 74 million is provided in surety bonds. So a pretty even split between the two types of instruments that are allowable under the council's rules. I provided a more detailed breakdown with Cicely's help, I should say, of the specific amounts and instrument types provided for each facility, and that's on page 2 of your staff report if you want to take a look at it. So you have a pretty good understanding now, or refresher now, on how the standard works. So I'm going to drill down a little bit more into how the instruments themselves work. So both surety bonds and letters of credit are pretty common, and they're both accepted as forms of security by many other state agencies and many other, contracting arrangements. But there are some important differences between the two, and there's some important differences between the templates for our specific templates that can affect the way they perform. And when I say perform, I mean pay out money, basically. So a surety bond can really be thought of as a three-party insurance policy that ensures that contractual obligations will be fulfilled by the principal who purchases the party. In this case, the contractual obligations that must be fulfilled are the obligations to retire the facility and restore the site as provided in the site certificate. And so how this three-part relationship really works is that there's a principal that purchases the bond and agrees to comply with the terms of the contract or the site certificate. There is then the surety that issues the bond, guaranteeing that the principal will abide by the terms of the contract, and providing that financial guarantee that if there is a breach of the terms of the contract, the surety will pay funds to the obligee up to the penal sum identified in the bond itself. And I do want to point out there that the surety's obligations are generally limited to paying out funds. They're not generally required to step into the shoes of the principal and complete the contract. And our bond template itself specifies that they wouldn't be responsible for any sort of site restoration activities. They're just responsible for paying out the money up to the amount identified in the bond. Okay, and then finally, the obligee, which in our case is the state of Oregon through the council, is generally responsible for establishing, monitoring, enforcing the contract and bonding requirements. And then just like an insurance policy, like I mentioned before, the obligee also has the obligation to provide documentation that a breach of the contract has occurred and to file a claim with the surety to review. And then the surety will see if that breach actually is something that would make it become liable under the terms of the bond itself. And so I won't go over the letter of credit in as much detail, but the letter of credit has a very similar arrangement, kind of the same three parties, but letters of credit are generally presentation based, which just means that instead of making a claim, the obligee really just has to present the letter of credit to the financial institution in the methods described in the letter of credit, and then the letter of credit will perform. Just to give you a sense of the different costs of the two, because the financial institution has a higher level of exposure to financial liability with a letter of credit, the carrying costs, either in terms of the amount of collateral that needs to be provided or the actual servicing cost itself, can be a little higher for letters of credit than bonds. Any questions there? Hearing none. So as I mentioned, the bond performs when the obligee provides documentation that the principal has failed to meet specific contractual obligations. And under our current bond template, the surety will only become liable if the principal has failed to fulfill its obligations to retire the site, retire the facility and restore the site as provided in site certificate conditions. Once that bond is in place, it can be amended through riders, surety riders, and that's how the amount is adjusted each year. And then the bond can be terminated, or I guess the surety's obligations under the bond can be terminated through several methods, and those are listed here. So the first one, and ideally the most common situation, is that the certificate holder fulfills its obligations, retires the facility, restores the site, and the council, determining that all those obligations have been met, will release the bond at the same time the site certificate is terminated. The second pathway to have a surety released from its obligations is if the principal provides an alternate security that's approved by the council. So that happens sometimes when a certificate holder comes forward and say they're changing financial institutions or changing their bond servicer. And then the next two pathways are a little more problematic for the council. First, the bond can expire. The terms of the bonds that we have on file now are generally between 1 and 3 years, and the extensions are granted through those annual inflation riders. But if no action is taken, so if somebody were not to go through and get that annual inflation adjustment, the bond would expire. And then the last way is cancellation, and that's in the middle of a bond term, the surety itself can take action to cancel the bond. And it needs to do that by providing a 100-day notice of intent to cancel to both the principal and to the department. And I wanted to pull up the language here about cancellation just to show that under our current bond template, the remedy for cancellation of a bond is that so I guess to go back a second. So if the bond is canceled or expires, the surety no longer really has any obligations to the state. They're not a party to the site certificate, so their obligations are really between them and the principal. As this shows, if the bond is canceled and there's no replacement, the department's current remedy is to go through the enforcement process, which is described generally in Division 29 of your rules. If it requires the council to wait until that notice of intent to cancel the bond has been given, that's a 100-day notice. The council or the department then have 90 days really to try to get the certificate holder to come into compliance and provide an alternate surety bond or letter of credit. And if they don't, at that 30-day mark, the council can go ahead and start taking its enforcement actions. And I provided a little timeline of how that will work here. So as you can see on day 1, we have that notice, and that starts the clock basically for the department to start sending its what are sometimes called nasty grams, but really compliance letters saying you need to provide us with an alternate bond or an alternate instrument, replacement security. At day 60, I would imagine that we would be sending a more forceful order, ordering them to provide us with the alternative financial assurance. By day 90, at the day 90 clock, if there was still no replacement, we would start the formal enforcement process, which is kind of where this timeline splits off. And I specifically presented it as a split here because the enforcement process really has no bearing on the validity of the bond. We can go through our enforcement process and assess civil penalties or impose other sanctions, but the surety can still, or probably will, still cancel the bond at day 120. As you all may remember, we went through the Division 29 rules pretty recently. That process consists of a notice of violation, And then the responsible party has an opportunity to provide a written response and the opportunity for an enforcement conference. And all that has to happen before the department or the council, in this case, can issue its notice of penalty assessment. And I have used civil penalty assessment as a example here, but other sanctions include revocation or suspension of a site certificate. And things like that. In any of those cases, the notice of penalty assessment or the notice of suspension or revocation would be subject to a contested case. And then only after that contested case could the council issue its final order actually imposing those sanctions. There are some of those steps that can be compressed in time, but in general, they would take more than that 30-day window. So while that is ongoing, the council may be in a position where it's left with no financial assurance. And in the case where these sort of enforcement proceedings are going, that's probably not the time when the council wants to be left with no financial assurance, particularly if the surety has also decided it wants to terminate its relationship with the principal. So we have presented a number of changes to the site, the surety bond template that would first kind of make the principal's failure to provide an alternate financial assurance instrument after the surety has provided its notice of intent to council a breach that would become that would basically cause the bond to perform. I've included this language here. I'm happy to pull up the red line language that we've had. But basically, we do think that this would really close what's not necessarily a loophole, but a significant source of exposure to financial liability on the state. Because like Sarah said, these bonds really do need to stay in place until the facility is fully retired, and at the end of it is really when you absolutely need to have it there. So we think this would provide a lot more security to the council. And basically our language would do this. So we would still have 90 days to try to recover the bond, or to get a new bond in place voluntarily. We could still take enforcement action as well. That wouldn't be precluded, but at that day 90, if there wasn't some indication from the principal that they were going to provide us with an alternate, the department could make a claim with the surety, and the surety would be required to pay monies up to the penal sum of the bond. We've also proposed changes that would remove the clauses for expiration of the bond, so that this process for cancellation would be the only way for the bond to terminate prior to its release upon successful completion of retirement and restoration of the site. We also attached the template for the letter of credit to the staff report here. We're not proposing any changes there, but we wanted to point out that the letter of credit already works like that. Essentially, it contains an evergreen clause where it would expire after 12 months, but it automatically renews unless the issuing bank takes some sort of action to non-renew. And it includes in one of the exhibits that it's a template for presentation, that failure to provide an alternate after the bank has taken that non-renewal action would be one of the reasons that the department or the council could make a claim on the letter of credit, or a draw, I guess, as it's called for letters of credit. Are there any questions about the language we're proposing, or any of the issues I just discussed?
Madam Chair, this is Hanley.
Sorry, go ahead, Hanley.
Yeah, so Chris, let me see if I get this right. So what the language that you're proposing is that the surety has given notice of its intent to cancel within, and then the principal has 90 days to replace the surety. But if they don't, then at the end of 90 days, does the department then require that the surety pay the state?
Yes, and I'm going to go back to this timeline slide just because I think it's helpful. But yeah, what you said is correct, Chair Jenkins. The surety has to give that 120-day notice. And so it can't cancel the bond until that 120 days has expired.
Right.
How we've written it is that the surety and the principal would still have, well, basically the principal would have that 90-day period to get a replacement in order. After day 90, we wouldn't necessarily have to make the claim on day 91, but we would need to make it in that 30-day window before the bond is canceled. So if on day 90, you know, the principal said, well, wait, you know, we have one, it's coming, we'll have it to you next week. You know, the department could still give them that time, and then if that time elapsed, make the claim. But we would need to probably take a hard action prior to day 100.
Yeah, my concern is that the surety, somebody stretches the clock out beyond the 120 days and the surety goes away. So, I mean, there's obviously have to take action within that 30-day window between 90 and 120 if nothing happens.
Yes, and we included that language specifically. I will say some of you know that I previously worked in the workers' compensation world, and in that world, if you make a claim in the effective period, or if you make a claim for something that occurred during the effective period of a bond, it doesn't matter when you make the claim. It just has to be for a violation that occurred within that effective window. We didn't know if that would be appropriate in this case, so this is language that was recommended as providing some reasonable assurances that, you know, a surety wouldn't be liable to exposure at sometime after they've released the collateral or they've, you know, released the principal from their obligations.
So basically the time clock would stop once you call the bond. Once you call the bond.
Yeah, once we call the bond and make the draw, you know, it could still be canceled and those obligations could still terminate. And then it would be up to the surety and the principal to sort out, you know, who's responsible for paying the money back.
Okay. Got to be paying attention. Can't let that 30 days go by.
Right.
Okay, thank you.
Chair Grail, this is Cindy.
Go ahead, Cindy.
So I just want to make sure I'm clear. What we are in that same situation today that Hanley described. I mean, we're in this time frame today with how the bonds are written, right?
Well, Councilmember Kondo, I am not aware of any surety that's provided a notice of intent to cancel.
Yes, no. If they did provide a notice of intent to cancel, we don't have, what we're trying to do is correct, or at least as I understand it, to put language in there that doesn't allow that running out the clock, which can occur now.
Yeah, and I guess I should have said this, and sorry, Councilmember Condon, I should have noticed. So right now, the bond performs only when we find that the principal has failed to meet their obligations to restore the site and retire the facility. And the council needs to wait 2 years from the date that a certificate holder has permanently ceased construction or operation of the facility before it can decide that there's been a violation occurring meaning that they haven't actually retired the site as required by the rules, because the rules give that 2-year grace window. So if the bond were to expire or be canceled in that 2-year window, the council would really be left without a remedy at all, because cancellation and failure to provide a replacement is not something that causes the bond to perform under the current template language. So it would just evaporate, and there'd be no course of action for the council. And if your legal counsel would like to add something, I just saw his video pop up. I welcome his comments, or maybe not. Okay.
I didn't have anything to add.
Okay, sorry, your video came up, and
And just one more thing. So the penal sum, just can you define penal sum?
Oh, sure. That's just the maximum amount that the surety will pay out. And that's the amount that's adjusted by the inflation letters every year. So.
Okay, so it's the face amount?
Yes, exactly.
Yeah, okay. Thank you.
Other questions, comments?
I think this is Cindy, Chair Grau, sorry.
Go ahead, Cindy.
I think this greatly improves the language. Thanks for the work.
Thank you, Chair.
All right, Christopher, I see you put up, someone else going to speak. Kent, is that you?
Yeah, Chair Grill, I had a question. Chris, if you could go back to that where the fork in the timeline occurs at 90 days, is the way the graph is read there, that upper line from the department issues notice of violation to collections is all supposed to happen within the next 30 days from day 90?
Councilmember Howe, that line is not to scale, but I think it's safe to say that timeline could realistically not all occur in 30 days.
Yeah.
The default time frame for the party to give a written response to a notice of violation in the rules now is 30 days. That can be compressed, so we could give a 7-day window, but those steps all need to be completed, and there are timeframes associated with each of them. So I would say it would be very unlikely that we would have a final enforcement order out within 30 days, unless there's some sort of emergency procedures that could be applied.
Then is there is there anything to prevent the department from issuing a notice of violation back on day 60 instead, and give 60 days for that to occur instead of just 30? Or does it not work that way?
Councilmember Howe, that is a good question. I would need to look at the way that the mandatory conditions are written. I know that since this 90-day period is provided in the current template, that could be adjusted perhaps, but it is implied that we would give them the full 90 days. It is possible that the department could issue some sort of compliance order prior to that, and then enforce that compliance order with a shorter time frame, but I'm not sure.
Yeah, it just seems like since the surety has issued a notice of intent to cancel, then things could start at day 30 instead of day 90 to kind of start dealing with it.
If I can jump in just to kind of respond a little bit. So for the record, Todd Cornett. So right now, the remedy is using the enforcement procedures. We don't actually think that that's the right remedy, partly because it's the time frame. If you're talking issuing the notice of violation all the way through to collections, I mean, realistically, that could be 9-month process, playing out all of those. Even with compressing it as much as possible, it's not going to happen certainly within 30 days, but 60 or 90 days, it's just not realistic. And so If the bond is canceled and it's no longer in existence, then the only alternative going through the enforcement procedures is collections. And even if council determined the collections, and I can't remember, Chris, you can correct me if I'm wrong, even if you could collect the same amount as the bond, that goes to the general fund. That does not go to the council. It does not go to the ability to decommission the facility. So, whatever the maximum amount is that you could collect, it wouldn't be directly applicable to decommissioning the facility anyway. Now, I don't know if the sort of state government would give us back that money to do it for that purpose. But again, I don't even believe that the council would have the ability to, have a sum in the amount of, what the bond currently is. But again, Chris has a better understanding of that than I do.
Thank you, Secretary Cornett. Yeah, I would just add that, the civil penalty would be for the violation of failing to maintain adequate financial assurance. The amount of that is not necessarily the same amount that would be due to the facility, and there's a statutory cap of $25,000 per day on the amount of civil penalty the council can assess, and the amounts are actually much lower than that set by rules. So unless that was enough to compel them to get us a new surety bond, that's really the effect there. As Secretary Cornett said, that those monies would be submitted into the general fund, and really the council would need to resort to some sort of civil action to recover the retirement or restoration funds. That would be, successful potentially if that's an active business, but as you all probably know, like recovering funds from a business that dissolves or goes bankrupt is extremely difficult. So, the options to be limited if there's no bond or letter of credit and the certificate holder decides to walk away are pretty limited. There's a lot of financial exposure
there. Chair Grail, this is Jordan, if I may.
Yes, please, Jordan.
Can we go back to the language real quick, please? Or forward, I suppose. If the surety provides notice of intent to cancel, while I know that there's a process for notification, I'm wondering if this language is a bit vague as to how that notice is given, or if it should correlate back to the method of notification. My mind instantly goes to provides written notice of intent to cancel, or whatever the appropriate avenue of notification would be, so that it ties this to that process.
Councilmember Truitt, if it's okay, I will pull up the red line language because I think there may be more specificity in the actual bond template, but I don't know off the top of my head. So, 1 second, please.
So while you're doing that, Chris, I want to go back to Kent's comment. This is Hanley. Marcy, I better have you.
Go for it, Hanley.
So my understanding is once we get to 90 days, based on the language that's proposed, once we get to 90 days and there is no replacement for the surety, then the department doesn't finish going out the timeline. The department calls that bond. Yeah. So I think maybe that answers Kent's issue or concern. The language that's proposed does not wait until we get to the end of the process. it waits until the 91st day and then calls the bond. If I understand this correctly. Surety will be obligated to pay the monies to the department.
Yeah,
Councilmember Jenkins, I can confirm that that is the intent.
Thank you.
yeah, and I would say that, not necessarily on the 91st day, but certainly before the 120th
Sure.
day, that's for sure.
Yeah. I mean, you have the opportunity on the 91st day.
Correct.
Yeah.
Yeah, thank you for clarifying that. That brings up my comfort level a lot. Thanks.
Councilmember Truitt, I pulled up the language under condition 5 of the bond here. So I did asterisk that out in the presentation, but we did, the current template does specify that notice needs to be given in writing. The current template only specifies that it needs to be provided to us. We did propose amendments here to require that it also go to the principal and the obligee. That's probably covered in the servicing agreement between the principal and the surety, but we thought it would be appropriate to ensure that the same notice is sent to both us and the principal at the same time, especially given the higher consequences that we're proposing.
I just, I guess the reason I bring that up is different people read different agreements differently. And I see this a lot in my day-to-day work where one paragraph will say, as it does here, or one section will say, provide written notice. And one group may interpret that to say, well, written notice to just this one address, or is it email, or is it a certified letter? And the method is not of my question here, but just for continuity and clarity to ensure that it reads consistently through, that is it written notice, or is it a must meet all the qualifications of written notice, et cetera. And I think it's probably fine as it is, but something that I noticed that I don't know, I could go either way with it.
So if I may, just to kind of respond more generally to Councilmember Truitt and other comments that were made, if you're comfortable with the language that we've recommended today, then, absolutely, approve it. If you have changes, certainly, make those changes and approve that. But we're not, there's no need to absolutely do this today. If council members, based upon this overview, this discussion, I think these good questions, and kind of discussions about this, if you want more time to look at this language and think about it, we can bring it back to you next month as well. So I just want to throw that out there as an option.
Thanks, Todd. Jordan, do you have something specific that you would like it to say?
Well, that's what I pay lawyers for in real estate, for them to figure out that language. So.
I think what you're asking for, Councilmember Truitt, is in paragraph 6, you would just want us to say written notice, if the surety provides written notice. So that would be the continuity between paragraph 5 and 6.
It's just one word, but you're the legal professional here, Patrick. If I will follow your recommendation on it. I'm just, yeah.
I've done this wordsmithing over contracts so many times in my career, and you look at it once and you think it looks great, and then you look at it 3 days later and you think, it could be improved. So, I mean, sitting here right now, I think adding written notice is certainly, it is, I think it's certainly implied because that's what it says in paragraph 5, but right. I don't see any harm in adding the term written.
Yeah.
Thank you, Patrick. This is Marcy, and I have that problem because when I go through my day-to-day work, people pick one section of the contract and they don't read the next paragraph, and it causes me to have to see my hairstylist more often than I care to cover the gray. So if I had to say, I would say inserted, but I'm just one voice here.
So why don't I try a motion?
Okay, thanks, Hanley.
Okay, Madam Chair, I move the council amend the template for surety bonds for use for site certificate holders with the following changes to staff's recommendation in, is this an item? Is this in point 6? The language reads, if the surety provides, add the word written notice of intent to cancel this bond in the rest of the paragraph. Otherwise, as presented by staff.
Thank you, Hanley. May I get a second, please?
Yeah, this is Kent, and I'll second that.
Thank you, Kent. Any further comments, questions? Hearing none, Mr. Secretary, please call the roll.
Hanley Jenkins,
Yes.
Perry Chalktoot,
Yes.
Kent Howe,
Yes.
Marcy Grail,
Yes.
Jordan Truitt,
Yes.
Cindy Condon.
Yes.
Motion carries, Madam Chair.
Thank you very much, Christopher. Thank you for your efforts on that. We appreciate it. So next on the agenda is agenda item H, which is the initiation of radioactive waste materials rulemaking. This is an action item. We will have Maxwell Woods, Odo Assistant Director for Nuclear Safety and Emergency Preparedness, Jeff Burright, Odo Nuclear Waste Remediation Specialist, and Christopher Clark, Odo Rules Coordinator, who will provide their recommendations for the Rulemaking Advisory Committee appointments associated with the OAR 345 Division 50 rules defining radioactive waste related to the recently passed Senate Bill 246. Max, Jeff, Chris, you're up.
Hi. Thank you, Chair Grail. Once again, for the record, this is Christopher Clark, the Council's Rules Coordinator and Odo Citing Policy Analyst. I believe Max is on the phone, but Jeff Burright actually will not be joining us today. So,
thank you for that clarification.
Chair Grail, thanks for having me and thanks for having us. It's glad to be back there. But can you believe it's been a year, by the way? It's been a year that I haven't been with FSEC, so good to see everybody.
We still miss you.
Thank you. I do have my colleague Tom Cecilia is on the line. If we have some technical questions, I may call on him to help answer those. Chris mentioned Jeff couldn't make it today, so but we've got you covered. Chris is going to go through a great presentation, and we have an ask here at the end for council, and we'll let Chris take it away.
great. Thank you, Max. So I believe Chair Grail covered most of what we're doing here. This is really an update on presentation that Max and Jeff provided back in June, I believe, on the passage of SB 246. During our presentation, we'll be giving some background on that legislation and then the kinds of materials that we're interested in this rulemaking. And then we'll give a quick rundown of our recommendations for the conduct of proceedings, including the need and authority for rulemaking, our proposed objectives and scopes, the potential impacts on different stakeholders, and our recommendation for the appointment of a rulemaking advisory committee. We'll conclude with a brief overview of our projected timeline before we turn things over to the council for your deliberation. Just as a reminder, we are very much in the early informal stages of rulemaking. I guess we're not even there yet. We are still scoping out this rulemaking. So we do welcome any feedback the council has to provide on any of these recommendations. Senate Bill 246 passed during the 2021 session, and that bill mandates that the council adopt standards and rules as necessary to prevent the disposal of radioactive waste in Oregon. It also provides the council with additional statutory authority to modify the types of materials that are considered to be radioactive waste under state law, and expands the authority of the council and department to investigate and enforce violations involving radioactive materials and wastes. The bill is effective on January 1 of next year, but we do want to get a head start, particularly in light of the importance and public interest in this issue, which is part of the reason we are asking you to initiate rulemaking today. So RS 469-525 is the law that prohibits the establishment, operation, and licensure of any radioactive waste disposal facility in Oregon. As I mentioned, this law has been, it will be amended by Senate Bill 246 to expand that to also cover a prohibition on the arrangement for disposal of radioactive waste in this state and the transport of radioactive waste for disposal in this state. We want to point out that the law prohibits the disposal or arrangement for or transport of radioactive waste in Oregon, but not all radioactive materials are considered radioactive waste. Radioactive waste is defined as material which is discarded, unwanted, or has no present lawful economic use and contains mined or refined naturally occurring isotopes, accelerated produced isotopes, and byproduct material, source material, or special nuclear material. So it's a subset of radioactive materials. It's basically things that are discarded and things that contain radioactivity is radioactive waste, except there are a number of exceptions. Those include some older materials, and then also materials that the council has identified by rule as presenting no significant danger to public health and safety. The current law references rules that were adopted back in 1978. And because of that reference, the council was only allowed to add new isotopes and concentrations to the list. So things have changed quite a bit since the 1970s, and there's been a lot of advances in our understanding of how low levels of radiation affect public health and safety. And so one of the reasons we think behind Senate Bill 246 was to allow the council to update the rules based on that current science, and also on the current kind of policy landscape of what other states are doing. So just give a little illustration. I believe you've seen this slide before, but when we talk about radioactive materials, particularly low-level radioactive materials, there's really two branches. There's human-made materials that are generated through a nuclear reactor or particle accelerator. Those are considered to be radioactive waste that are prohibited from being disposed of unless they fall under a specific quantity or concentration exemption under Division 50 rules. And then there's naturally occurring radioactive materials, and those are things like ores or mineral sands containing uranium, thorium, or potassium, and their decay products. And those are also considered to be radioactive waste if they exceed certain quantities and concentrations. But they can also qualify for a pathway exemption from the prohibition on disposal if it can be shown that the accumulation of disposed waste cannot result in exposures exceeding 500 millirem of external gamma radiation per year. That threshold is one of the things we would like to be looking at in this rulemaking, because I think that was, while that was consistent with guidance, I think previous, and maybe Max can correct me exactly when the update happened, but at the time the rules adopted, that was the latest science, and it has been lowered significantly since then. And we want to point out that the impetus behind the bill and this rulemaking were really an increase in the production of what is called technologically enhanced naturally occurring radioactive materials. And those are materials that contain those naturally occurring isotopes, but some sort of industrial process has either increased the concentration or increased the likelihood of human exposure. And so that includes things like mining, milling, burning. It also includes things like filtering waste from oil and gas extraction. And so there's a lot more demand for disposal of those kinds of materials now in the West, and perhaps in other parts of the country. And the department really wants to make sure our rules are consistent and keeping pace with other things that Western states are doing to help prevent those materials from being disposed of here in Oregon. So through the informal phase of this rulemaking, the department would evaluate whether changes to Division 50 are needed to protect public health and safety. We would be considering what, if any, additional standards or rules are necessary to prevent the disposal of radioactive waste in Oregon. And then we'd be identifying whether any conforming changes were needed to other parts of OIR Chapter 345 to implement the bill or the new rules. And we would be particularly looking at the rules in Division 29, which are, again, the council's enforcement rules, just to make sure that the rules the council adopted earlier this year are still appropriate and up to date. We would then come back to the council with our recommendations for proposed rule changes. That would initiate the formal proceedings, formal rulemaking proceedings, and there'd be an opportunity for public comment and hearing on that too. We do want to note that while this rulemaking could have implications for the regulation of materials other than norm and T-norm materials, certain materials, as I mentioned before, are statutorily exempt from the provision of ORS 469525 and therefore outside of the scope of this rulemaking. And we just wanted to make a particular note that that includes special nuclear materials currently stored at the Trojan ISFC. But the council is conducting a separate rulemaking related to the ISFC, which is the Independent Spent Fuel Storage Installation at the former Trojan nuclear plant site. And we'll be presenting our draft proposed rules for that project in the next few months. Okay, because this is a rulemaking that involves, potentially involves the establishment of new regulatory requirements, including but not limited to things like monitoring or reporting requirements that would be applicable to a regulated industry. There's a potential for some fiscal and economic impacts, including increased cost of compliance for industries that produce, handle, or dispose of radioactive materials. Due to that potential for fiscal and economic impact, and due to the generally high level of public interest in issues related to radiation and public health more generally, staff is recommending that council appoint a rulemaking advisory committee to assist in the development of draft proposed rules and identify potential fiscal impacts, including potential fiscal impacts on small businesses, which is something that we are statutorily obligated to look at. If the council approves our recommendations to appoint a RAC, and I'm going to go over specifically who we are recommending be included in that RAC as of now, we're also requesting that the council delegate authority to the department to appoint additional RAC members as needed. For clarification, when I ask for that authority to be delegated to the department, I don't mean me, but I do mean either Max Woods, who's on the line, Todd Cornett, or the director herself. So to get to the actual composition of the RAC, this was the slide that was presented to you back in June. After that meeting, the Nuclear Safety and Emergency Preparedness Division and I started conducting initial outreach to these different stakeholder groups, prioritizing the different interests and perspectives shown here. So briefly, that includes public interest groups, regulated industry, radiation health professionals, environmental justice communities, people with knowledge of the history and context of radiation protection in Oregon, tribal governments, county governments, and the public at large. Outside of the RAC process, we do also plan on coordinating with federal agency partners and other tribal governments that aren't participating directly in the RAC. We have confirmed interest from another number of organizations and individuals. I'll go through these briefly. For public interest groups, we've confirmed the League of Women Voters of Oregon and Physicians for Social Responsibility. Representing regulated industry groups, we have Waste Management, the Oregon Refuse and Recycling Association, and Oregon Business and Industry. For local governments, both the Association of Oregon counties and Gillum County have expressed interest, as has Oregon Metro. One tribal government, the Confederated Tribes of the Umatilla Indian Reservation, has expressed interest in participating. And then we've invited two of our sister agencies, the Oregon DEQ and the Oregon Health Authority's Radiation Protection Services team, as well as the OSU Radiation Center to participate on the RAC. And then we have a couple of unaffiliated members of the public with a lot of subject matter expertise that have also expressed interest in participating. David Smith was the siting division administrator here at the department for many years and has a background in radiation safety, and also participated on the Division 29 RAC, as have some of these other organizations. And then Dr. Wayne Lee is a certified health physicist that has an extensive background working on radiological health issues here in Oregon and elsewhere for a number of companies, including Portland General Electric. So that is our list here, and I'll just stop to see if the council has any initial impressions or feedback on this list, if you think anyone is missing, or if you think anyone is included that maybe shouldn't be. So,
Anyone have any questions, comments?
okay.
Hearing none, Christopher.
Hearing none, we can come back to this if needed, but otherwise, to give you a quick idea of the timeline we are considering, and we're not asking council to approve this or to adhere to this strictly, but if the council initiates rulemaking today, we would likely begin convening the RAC in the coming months, so September, October, and that would extend through February. I think we're anticipating the need for somewhere between 3 and 6 RAC meetings. As that process is wrapping up, we'd be drafting our proposed rules and would hopefully be coming to the council with draft proposed rules and a draft notice of proposed rulemaking in April for your consideration. Considering that the council is ready to go with proposed rules at that time, there'd be the formal public comment period and a potential rulemaking hearing, as I mentioned before, and that would allow the council to consider the adoption of permanent rules sometime in mid-2022, but hopefully by July. So that's what we're looking at. This is a little bit more of an extended process, but we do think that that should be manageable. And unless there's any other questions, I'll go ahead and turn this over to the council for deliberation. We have split our request into 2 items for your decision. First, we're asking for your, the council's action to initiate the rulemaking and appoint the RAC, and then we've presented the issue of delegation of authority to appoint other RAC members as a second item. I'll leave that to the council to decide whether you want to address those separately or together. But.
Well, I think since you asked for it to be done separately, that makes sense to me. If no one has any objections to doing it separately, then I think we should. Any objections? Hearing none, may I get a motion for the first item?
Yeah, Chair Grail, this is Kent, and that was a very well done presentation, Mr. Clark. So, Madam Chair, I move that the council initiate rulemaking to amend OAR Chapter 345, Division 050, and implement Senate Bill 246 and appoint the individuals and organizations identified by the department to a rulemaking advisory committee to assist in the development of proposed rules.
Thank you.
Mrs. Hanley.
Thank you, Hanley. We have a second. Any discussion?
Chair Grail.
Yes, Cindy.
Cindy Condon. Quick question, Chris. I should have asked you this earlier. Is Columbia? I didn't see Columbia Riverkeeper on the list of suggested RAC members. I know they testified. Thoughts on that?
Councilmember Condon, we did reach out to Columbia Riverkeeper and see if they were interested, and they let us know that they just did not have capacity to serve on the RAC at this time.
Okay, thank you.
Great question, follow-up, Cindy. Thank you. Any further comments, questions?
Well, this is Hanley, Madam Chair. So
Yes, Helen.
what about, isn't it PGE that had Trojan? Are they, they don't appear on your list.
Councilmember Jenkins, yes, PGE did actually reach out and they expressed interest in participating on the RAC. We did not include them in the recommendation, partially because we think issues related to Trojan are outside of the scope of this rulemaking. That is obviously the council's ultimate decision.
Okay.
Thank you for that. Any further comments, questions? Mr. Secretary, please call the roll.
Marcy Grail,
Yes.
Cindy Condon,
Yes.
Kent Howe,
Yes.
Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Hanley Jenkins.
Yes.
Motion carries, Madam Chair.
Thank you, sir. The second item, the request for delegation of authority to appoint additional RAC members. Is there anyone interested in making a motion?
Yeah, this is Kent again, and I'll move that the council approve the department's request for authorization to appoint additional individuals or organizations to the RAC as needed.
Thank
I'll
you.
second that. This is Hanley.
Thank you, Hanley. Any questions, comments? I would just like to say for the record, I know the public has made comments about us as council not owning our responsibilities, and I believe this is a perfect thing to delegate. We're all well aware what the issue is, and I don't think we should have to wait to convene to continue moving the process on. So I just wanted to state that for the record. There's no other questions, comments, then we have a motion and a second. So Mr. Secretary, please call the roll.
Perry Chalktoot,
Yes.
Hanley Jenkins,
Yes.
Marcy Grail,
Yes.
Cindy Condon,
Yes.
Kent Howe,
Yes.
Jordan Truitt.
Yes.
Motion carries, Madam Chair.
Thank you. I just want to check in with everyone. Is everyone okay? Anybody need a 5-minute break? We still have a little bit more to do. Okay, well, then we'll keep trucking on. Our next item is agenda item I, application process review rulemaking. This is an action item. Christopher Clark, Odo Rules Coordinator, will request council initiate the application process review of rulemaking project. Christopher, the floor is yours.
Thank you, Chair Grill. Once again, for the record, this is Christopher Clark, Odo Setting Policy Analyst and the Council's Rules Coordinator. And thank you all for bearing with me. Hopefully I am not putting anyone to sleep yet. So during this agenda item, we are asking that the council initiate phase 1 of a rulemaking to review and revise rules for the application review process, which are primarily located in divisions 15 to 25 of OER Chapter 345. As I'll explain in a little more detail, this phase is primarily intended to reorganize rules in a way that sets more clear boundaries between the procedural and substantive requirements that applicants, the department, and the council must meet, and to clarify and simplify procedures for the review of site certificate applications where possible. I do want to note that while we have a general idea of the direction that we want to go with this phase of the rulemaking, we would really appreciate any additional feedback that the council has on the overall direction you want to go with the rules, with your rules and the procedures for reviewing site certificate applications, the sequencing of rulemaking that we're proposing, and any specific areas that you think we should address either during this phase or during other phases of the rulemaking while we're presenting here. So just to put that in your minds. Similar to the last agenda item. During this presentation, I'll be giving some background on the origins of the project, and then I'll give a quick rundown of our recommendations on the conduct of proceedings, including need and authority for rulemaking, objectives and scope, potential impact on stakeholders, and our recommended methods of obtaining public input. And we, again, have a brief timeline here to give you before we conclude and turn it over to you for deliberation. So this rulemaking project has really been in the making for quite some time. As Sarah presented a little bit earlier in her overview, the financial assurance standard, the council's rules have gone through a number of overhauls. Generally, those were, in response to major statutory changes. So there was a big change in 93 and 95. And then another kind of cycle of rulemaking in 1999 and 2002, and then a little refresher in 2012, but there hasn't really been a comprehensive overview of the siting review process rules in some time. We kind of wanted to center this rulemaking around making better connections between the standards and the information requirements that are required in Division 21 specifically. But we'd also like to review this application review process procedures a little more carefully. So to give a little background on that, so as Sarah mentioned as well, the council has adopted 14 general standards that are applicable to the siting of all energy facilities in Oregon. And then there are a number of other specific standards that are applicable to the siting of specific types of facilities. Many of the general standards began as specific requirements for nuclear and thermal facilities, kind of reflecting the council's predecessor, the Nuclear and Thermal Energy Council. But over time, they've been made more general to reflect the transition to, I think, first the gas in the early 90s and now to renewable energy production. So as those standards evolve, the application requirements and the procedural rules also did. But over time, the relationship between those information requirements and the standards themselves have become a little less clear. So we came to the council with a proposal to work on a multi-phase rulemaking project to update, clarify, and simplify the procedural rules for the site certificate application review process as part of your 2021 to 2023 rulemaking process or rulemaking schedule, and the council approved us to begin our initial work there. The project was also identified in the department's implementation plan for Executive Order 2004 as a possible means to accelerate reductions in greenhouse gas emissions by improving efficiencies in the siting process. The council is generally authorized to adopt standards and rules for the siting of energy facilities and for the implementation of Oregon's energy policy. We want to note that the process for the application process, or sorry, the procedures for the application review process are generally described in ORS 469 330 to 370. And while that really lays out the major milestones that need to be met and a lot of the administrative procedures around noticing and public engagement, there's still a lot of leeway on exactly how the council conducts its process. Some of the steps that are currently in the rules aren't required by statute. Some of the steps currently required by statutes, which happen, are described in the rules. And so we think that this rulemaking is needed to clarify and simplify those steps, to clarify and simplify application requirements, to improve consistency and standardizations in the review process, and just to make the process clearer and more understandable for applicants, reviewing agencies, and interested members of the public. The rulemakings are intended to create efficiencies and reduce the time and costs associated with state jurisdictional review, while having no negative effect on public participation. And I want to say that that language is lifted directly from the EO 2004 implementation plan But as we're going through this, we will really be looking for ways to enhance opportunities for public participation. While not necessarily adding new opportunities, we do want to see if we can make those existing opportunities a little bit better. So to address those goals that I've just discussed, we've broken the project down into 3 main objectives, and we plan to tackle one of those objectives through each phase of this rulemaking project. So phase 1 is to separate the procedural and substantive rules to simplify and clarify procedures where practicable. Phase 2 is to take a deeper dive into the application information requirements and to make sure that those information requirements align up with the requirements of the standards themselves. And then phase 3 will be to look at the standards and the substantive requirements and see if they are appropriate for different types of energy facilities, particularly renewable energy facilities. And then we would make adjustments if warranted. And we do want to point out that since we kind of did the initial scoping for this rulemaking process, HB 2021 passed, and that really limits the decisions that the council can make to approve new fossil fuel powered energy generation facilities. So we may also want to kind of relocate some of those standards that are and rules that are applicable to existing fossil fuel power generation facilities to kind of, I guess, put them out of the way if they won't be used regularly to make our rules more clearly appropriate for the types of facilities we expect to see in the future.
Hey, Chris, before you leave this, actually, yeah, can you go back to that slide? Because I think this helps looking at it from this phase. So just a little more kind of description. So phase 1 really is just sort of alignment, no substantive changes. There may be some differences of where the rules are located, but the idea is just sort of that first step. So there's really no substantive changes as part of that rulemaking whatsoever. Phase 2, as we start to figure out what's the standard, what are the requirements to submit as part of that, to justify you've met that standard, that necessarily will start getting into some substance, but kind of in the middle. And then phase 3 is absolutely substantive. And phase 3 is probably more than just one rulemaking. There's probably a host of rulemakings, because if we start to look at specific standards, we can't deal with 5 or 6 or 14 standards all at once. It would just be substantively too much. So that one in of itself will likely have to be broken down in some way. We haven't figured that out yet. There's definitely going to be very iterative as we move through these series of rulemakings. But I just wanted to kind of forecast that out a little bit, at least what we're thinking right now at the staff level. So thanks.
Thank you, Secretary Cornett. Yeah, I think that's a very good description, and I think it is good to note that while I will not say that we won't make any substantive changes during this phase of the rulemaking, we are certainly intending to minimize the creation of new procedural or substantive requirements. And actually, we will try to avoid, to the extent possible, the creation of any new substantive requirements. But we may flesh out procedural issues or do a little housekeeping around the procedures where that makes sense, and if there's low picking fruit, I would say, low hanging fruit. Okay, so as we showed on that last slide, the scope of phase 1 is really to reorganize the rules in Division 15 to Division 26 to create that clear separation of procedural and substantive provisions, and then to simplify or clarify procedures where practical. I've broken that down into 2 sub-objectives, and that is to separate out the procedural and substantive rules. And that's really where we're going to be reorganizing the rules to clearly identify what is substantive and what is procedural. And I'm going to go into depth into that in a little more detail because I think it's a little in the weeds of what we mean by that. And then our second objective is to simplify and clarify procedures where practicable. And that would just involve things like eliminating duplicative procedural requirements, consolidating procedural rules that are steps that are repeated at multiple points in the process, and then identifying if there's procedural gaps or unclear processes. And that's specifically if there's things that we're statutorily obligated to do or that the council just regularly does as part of its practice that aren't described in the rules. We'd like to fill those in so that the rules kind of do provide a complete, I think, A to Z overview of what the process actually looks like. So unless there's any questions on that, I'll go ahead and start talking about what we mean by separating substantive and procedural rules. Okay, hearing nothing. Okay, so the first step in any exercise where you're trying to separate out two different categories of things is to establish what the categories are themselves. And so in the scoping of this, we did a little work and we've come up with some working definitions for what we mean by substantive requirements and procedural requirements. So a substantive rule is a rule that establishes a right, duty, or obligation for an applicant or certificate holder. And examples of the substantive rules would include information requirements that establish the information or evidence that must be provided for the council to evaluate compliance with the standard. Standards themselves, and I'm sorry, does somebody have a question? Okay. So standards themselves, which in an old Supreme Court case, they describe as establishing the yardstick by which the evidence will be evaluated. And then others, substantive requirements include conditions or obligations that describe specific rights, duties, or obligations for the certificate holder. So those substantive requirements can come up at different parts of the process. They can either be included in the substantive requirements that must be met for completeness, substantive requirements that must be satisfied for the council to make its decision, or requirements that the certificate holder has an ongoing duty to fulfill. But those are in contrast to procedural rules that just prescribe the steps that must be taken and methods that must be used to implement a substantive rules. So example of the procedural rules include things like submission and noticing requirements, deadlines and timing considerations, procedures for agency coordination, public meetings and public hearings, and also evidentiary rules and rules assigning the burden of proof, which is a little bit of a gray area, but we've kind of put them here. And then not to get too meta while we're defining what the different kinds of rules are, but there's also definitional rules, which provide specific meanings for words in terms that may otherwise be ambiguous. And we just wanted to point out that there is a whole rule full of definitions, and there may be specific definitions included in each rule. Generally, those shouldn't be, they should not include substantive or procedural requirements. So as part of this process, we may be looking at the definitions and just making sure that we haven't mixed any substantive or procedural rules in there either. So to give a little bit more of an example of how this phase one might look, we have kind of presented here an overview, a very high level overview of what the site certificate application review process looks like. Generally, the steps for this process, as I mentioned before, are described in ORS 469-330 to 370. First, the applicant submits its NOI, and then after that initial public review and agency review, the department uses the information in the notice of intent to issue its project order. And that project order would describe all the substantive requirements that substantive standards and application requirements that the applicant needs to demonstrate compliance with or satisfy in its application for site certificate. The application for site certificate has a whole completeness review, which you are all aware of. And once we get to that completeness, the department issues its draft proposed order. Draft proposed order is subject to public review and public hearing. And after that process goes through and all the public testimony and agency comments are considered, the department issues a proposed order. And then at that point, the process really transfers from the department to the council. The council conducts the contested case, and at the conclusion of the contested case, issues its final order and site certificate. The procedures applicable to the department and to the council for this entire process are generally contained in Division 15. And that division also contains procedures for expedited review and procedures for review of exemption requests. So it's a pretty big division. Conversely, the procedures for the notice of intent and for the application are included, that are applicable to the applicant, are included in Division 20 and 21. So we have the procedures kind of spread across these three divisions. And one example of how we can create a little more clarity in the process is to reorganize Division 15 specifically to break it into its component pieces. So this is just an example, but again, I think it's helpful just to get a better idea of what this might look like. So our proposal here would be to take the contested case procedures and leave them in Division 15. And we may also want to look at whether or not those procedures are applicable to all types of contested cases or just the contested case on the application for site certificate. The council does have a few other actions that they take that are contested cases under law, and that involves enforcement actions and some other things. We would move all the procedures for the notice of intent to Division 20 and the procedures for the review of an application to Division 21. And then we'd break the procedures for expedited review and exemptions into their own divisions. And this could change, for example, we could include the expedited review procedures in the application for site certificate because there's a lot of overlap there. Just to get a little deeper into the weeds, as we're doing this, we would look for any of those rules that are currently separated that overlap. And then we would integrate them into a more linear divisions of rules. So in this example, we move the public noticing and distribution rules for the NOI between kind of where they go before the distribution of the NOI. We could maybe consolidate the memorandum of an NOI and the distribution of an NOI rules together because they actually overlap quite a bit. We'd include those public review processes towards the end and then maintain just the exact existing structure of Division 20. And then we do something similar for Division 21. So that's pretty straightforward, just reorganizing the procedural rules. But what gets more complicated is the application requirements and the contents of the NOI rules, which is in Division 20. And so Sarah mentioned this earlier, but there's currently 30 different exhibit requirements in Rule 21, Rule 10, which is the application requirements rules. The exhibits are really substantive to the extent that they specify what evidence must be provided for an application to be considered complete and what evidence is needed to determine compliance with the standard. But the rule and some of the individual exhibit requirements also contain procedural elements specifying how that information must be provided, when and how many copies, things like that. So in addition, the substantive elements in this rule are not all directly related to the substantive requirements of the standards. Some of them are, as we mentioned before, related to old standards. Some of them are substantive requirements that are actually related to completion of procedural steps. So it's pretty mixed up. And as an example, we've kind of identified a certain number of exhibits that just provide generally descriptive information about the facility and the proposed location. That descriptive information is important to the standards themselves, but they don't necessarily relate to the specific review of any particular standard. There are a number of exhibits that include information about impacts to resources protected under one or more council standard. So these include things like soils, which is directly related to the soil protection standards, but also include things like the materials analysis, which could be related to the soil protection standard or to other standards like the waste management or public services standards. And then finally, we have a few standards which contain information that's almost entirely procedural in nature. And a good example here is Exhibit F, which is the property owner lists, which are needed to satisfy noticing requirements, but aren't really related to any one of the standards. So that's just kind of an example of how the information requirement reviews in the applications is really blended. We would like to clean this up during this phase of the rulemaking, but we're not exactly sure how much of that we'll be able to do now and how much of that will need to wait until phase 2. So just to give you a quick look at where sort of the thornier issues might be, we do think that our proposal for scoping will help us kind of determine how far we can go in this process, in this phase. So as Todd mentioned earlier, phase 1 is not expected to create any new substantive or procedural requirements. And we are going to try to minimize any real substantive changes that occur. Overall, the project, so of overall 3 phases, the project's intended to reduce overall net costs of the siting review process by reducing time and administrative burdens. But we just want to point out now and make it very clear to both the council and to any stakeholders that some individual changes may actually increase costs by increasing the amount of information required to demonstrate compliance with individual standards, or by enhancing opportunities for public participation or engagement. We think even if those individual changes result in increased costs, we can still create more efficiencies in the process overall, and that some of these things, by doing a little more work up front, we may reduce the need for issues to be resolved through contested cases or through litigation later on. So we are looking at this in a very holistic and comprehensive way. And we're not just looking for ways to save money or save time. So, because phase 1 has a pretty narrow scope, and we are minimizing our substantive changes, there is the opportunity or the possibility that we could move forward with proposed rules without conducting a RAC or conducting extensive public engagement. But since the overall project has such broad implications, and because the issues are complex and there's a lot of different ways we could go through this, and because there's just a lot of interest in our review process in general, we are recommending that the council use a rulemaking advisory committee to assist in the development of the proposed rules. But before we get there, we think some additional early engagement is needed, particularly to scope out the issues that we'll be working on in phase 1, to get a better sense of the overall direction that we'll be going in phase 2 and 3, and just to identify the potential pool of interested stakeholders that may want to participate in the process. So we are requesting for our recommended method of public engagement that the council authorize us to issue a scoping survey prior to the appointment of a RAC, and then we would come back to you with kind of the results of that survey and our recommended RAC list at a later time. some of the potential questions we would have on that scoping survey are things like, what are your top priorities for making the siting review process more efficient and effective? What are the most important informational elements of an application? How could the content or formats of application be improved? How can opportunities for public participation in the siting review process be enhanced? And what are other comments and concerns? These are, pretty vague questions. We'll also be reviewing these questions in the context of the application or of the siting program review that is also scheduled to kick off pretty soon. But we do think that getting answers to these kind of questions would help us just refine our approach here early on. And we will definitely distribute this survey to the council members as well if you approve this approach. If you do have any thoughts on any of these things now too, we'd also be happy to hear them. But I will there just pause for questions or comments or any initial impressions.
Any questions?
This is Kent, and I just say that was another good presentation, Mr. Clark. And Madam Chair, I'd move the council initiate phase 1 of the application process review rulemaking project as recommended by staff.
Thank you, Kent. Is there a second?
Ms. Jordan, I'll second.
Thank you, Jordan. Do we have any other comments, questions?
So Kent, this is a question on the motion. Does that then include the scoping that Christopher's proposing with this?
Yes, that would be my intent because it's part of the
proposal by
staff.
Yeah. Okay. Okay.
All right, we have a motion and we have a second. Any further questions, discussion? Hearing none, Mr. Secretary, please call the roll.
Cindy Condon,
Yes.
Jordan Truitt,
Yes.
Marcy Grail,
Yes.
Hanley Jenkins,
Yes.
Perry Chalktoot,
Perry may be muted.
Yes.
got it. Thank you. And Kent Howe.
Yes.
Motion carries, Madam Chair.
Thank you, Mr. Secretary. Christopher, you spent the afternoon with us and we did not fall asleep. So thank you for your efforts in getting through those agenda items.
Thank you, Chair Go.
Excellent. Our last agenda item for today is agenda item J, PGE update on the Boardman coal decommissioning. This is an information item with Lena Cope, Portland General Electric Senior Environmental Specialist. Lena, you are up.
Hello, thank you. Can you hear me? Okay, and will I have control of my presentation or is that coming through? Let's see, it looks like maybe I can just share. Okay. Get things reorganized here for me. There we go. Okay, good morning, Chair Grail, Vice Chair Chow, and members of
Lena, excuse me.
Yes.
I don't know if it's just me, but I'm having a really hard time hearing you. Sound extremely far away.
Oh, okay, let's see. Maybe I will just talk louder. And also, let me try opening. That might mess up my screens though. Let's see here. Is that any better?
It is better. Can everyone else hear her?
Yes.
Yes.
Oh, thank you.
I'll be sure to keep my voice up. Okay.
Thank you.
Good morning, Chair Grail, Vice Chair Howe, and members of the council. As you mentioned, my name is Lena Cope. I'm an environmental specialist with Portland General Electric, and today we're providing an update on our Boardman decommissioning and demolition work. This presentation builds off the presentation I provided last October, so some of the slides may seem familiar, but I left them in to provide context for some of the new information and background for any new council members. This slide provides a high-level overview of the history of the Boardman Site Certificate. It was one of the first site certificates issued by the then Nuclear and Thermal Energy Council back in 1973. Sorry, we submitted the application back in 1973 and it was approved in March of 75. We amended, we began operations in 1980, and since 1975, we amended the site certificate 9 times, the last time being in May of 2013. We ceased burning coal on October 15th of last year, 2020, and during that time, the facility produced 97 million megawatt hours of energy. So this is an image of the Boardman area just to provide kind of a geographic overview of some of the features that we'll be covering during the presentation today. As many of you know, the site is located about 13 miles southwest of the city of Boardman. We have this area here is what we kind of generally refer to as the Boardman Power Block area. It's where the admin building, parking, power block, laydown areas are. This area here is the coal yard. This is our Carty generating station, which was built in or completed in 2016. We have Carty Reservoir, and this is the ash disposal area over here. There are a couple things not labeled on this slide that we will talk about during the presentation. One of them is a berm of soil kind of located here north of the plant, and another will be kind of the fueling station fuel island that is located in this general area. So keep that general in mind as we get to those slides. Can everyone still hear me okay?
Yes, thank you.
Okay. Here's a timeline showing the work that has occurred since 2019 and looking forward through demolition. As you can see, a lot of the tasks overlap and a lot of work occurred even before 2019, but late 2018, early 2019 is when the work really picked up. First consideration was figuring out what needed to be done to separate Boardman and Carty from each other so that Carty could continue to operate uninterrupted once Boardman was decommissioned and demolished. With the information from that separation evaluation, we came to the council with a request for amendment number 2 of the Carty generating station, and that was approved in November of 2020. And that allowed us to move some existing related and supporting facilities from the Boardman site certificate into the Carty site certificate, and then also allowed for the construction of a few new related and supporting facilities for Carty to support that separation. So we see here that we started reclamation of the coal yard in March of 2020. Our last coal train arrived in April of 2020. As I mentioned before, we ceased operations in October. Since then, we've been focused on decommissioning in order to make the plant safe for demolition, and we've been working on some very specific kind of cleanup and closure actions around the site that I'll cover in more detail later, such as closure of the ash disposal area and starting construction on the Carty substation. And then demolition, we expect to start potentially as early as October of 2021, which is, I think that the last update we provided, it was going to be in early 2022. So we're a few months ahead of schedule at this point. I've previously covered the worker transition, but wanted to touch on it again. We don't want to ignore kind of the impact to the workers of the area that the closure of the plant had. We had 67 employees as of October 1st of 2020. That number was down from, I think, about an average of 110. So a lot of workers had already chosen to pursue other roles in the area. So of the 67 employees that we had at October of 2020, 4 continue to be on site to support the site. 11 have transferred to new roles within PGE. 37 are classified as retired, which means they are of a certain age and had a certain number of years of experience that would qualify them for retirement. Therefore, can't say for sure that they didn't go out and seek employment elsewhere, but classified as retired, and 15 were laid off. Okay, in the next few slides, I'll cover the immediate actions that we've been taking at the site since we ceased operations. First, we'll cover the CARDI independence actions, which is that CARDI separation from Boardman. The list here provides kind of the high level actions that needed to take place, which was construct a new septic system. CARDI was tied into the Boardman sewage system, construct backup power for CARDI, address some new eye washes and fire line reconfigurations due to those aspects of Boardman going away, and some work at the intake structure to address pumps and transfer those controls for the intake structure from Boardman over to CARDI. And then lastly, we still haven't made a whole lot of movement on this, but CARDI Reservoir is oversized for just the operation of CARDI itself. So PGE does want to continue to evaluate if there's ways to kind of minimize that O&M cost associated with operating the reservoir, but don't have a whole lot of more information on that at this time. At the last update, we were, I think, nearly completed with coal yard reclamation. We started in March of 2020 and ended in October 2020, but have a few more pictures for you this time. We contracted with a company that used physical separation methods to separate the coal from the soil interface, and that kind of followed along the typical coal loading process, meaning as soon as our typical methods reached their limits of removing as much coal as possible, this company came in with what they called the Green Dragon, which you can kind of see here, and performed that soil coal separation process. We reclaimed about 40,000 tons of coal that we were then able to use for fuel, and diverted that from having to go to a landfill if we had waited to do this work once we ceased burning coal. So these pictures here show the Green Dragon, the various conveyor belts, and the various resulting piles of material, whether it be dirt or rocks or material that couldn't be burned or coal that could be reclaimed. This picture here you've seen before. It shows the coal yard as a whole, where you can see half of it had been reclaimed, the other half had not. This picture here is roughly taken in this area of that reclaimed area. This is CARDI generating station in the background there. So just another picture of what it looks like once the process was complete. A few more pictures showing before and after. This one here shows our typical coal loading processes happening back here and up here where those processes are complete. We've already come through and reclaimed. And then this is what it looks like roughly today. It was revegetated in January of 2021. And so you can see some plant material starting to come back on that former coal field. South of the plant is the ash disposal landfill, or also known as a coal combustion residual landfill, CCR for short. Closure requirements for this landfill are contained in 40 CFR 257, which is a federal regulation. And PG began the capping construction in May of 2021 and primarily completed in July of 2021. I say primarily because as of today, there are still a few punch list items to complete before it can be truly considered closed by CCR regulations. The area is capped with a geosynthetic material called closure turf. I know this might be kind of hard. I'm not sure how well it's showing up on your presentation, but these are the layers of kind of hypothetical layers of the closure turf. So you have your ash here. The black material is your geomembrane. You then have a geotextile. Turf fibers, because this is intended to kind of mimic natural grass, and then a specified infill that goes in between these turf fibers. And the rest of these pictures will kind of demonstrate each of those layers. You can see this is the ash landfill right in the corner here. You can see them just beginning to install the liner, the synthetic liner. There's a anchor trench constructed around the entire landfill. This picture here shows them rolling the liner out with a spreader bar, pulling the liner down into the anchor trench. They then come through and weld the seams together, pressure test the seams to make sure that everything is holding as impermeable, and then move on to the next panel. This picture here, you can see some of the turf fibers being installed over what is now a synthetic liner lined with a geomembrane, or I'm sorry, a geofabric. So it's just a comparison of, you can see the two different materials. This image here, they are installing rock armoring in some of the stormwater retention or stormwater drainage ditches that help drain the landfill, or the cap from the landfill. And then it's just kind of a progress shot. You can see Boardman in the background, Party Reservoir, Ash landfill, and just kind of more of a progress shot where you can see the various layers being installed. And then lastly, we have spreading of the specified infill, which was imported sand. So they just kind of a side-by-side with a trailer that shakes the sand out and spreads it across the landfill. Then they come through with kind of a brush to brush it into those fibers. And then you see the end product there of the completely capped landfill. Another activity taken at the site, in that overview map, I mentioned the soil berm north of the facility. And so this slide covers that soil berm. So the berm was the result of excavation of the boiler room. So this is where all the excess soil was stored after initial construction. For a period of time, it was used as a shooting berm for scoping and hunting rifles by the plant personnel. So given the known history of how that was used out there, we sampled the entire berm with a geoprobe and an auger to identify any contaminated soil. And you can see in the second shot, there was really just one small little area that required a little bit of kind of scraping of a bit of soil to remove some lead contaminated soil that was found. And so this first shot shows the berm as was before any work started. And in the second shot, you can see a little bit of where some of that material was scraped off. And it's 146 tons of soil. And then this picture up here is our, my coworker actually kind of went out there with a sieve to get a bunch of soil and screen it out and try to find some of those bullet fragments that were in the berm. So that's what this picture up here is of. PG had a fueling island at Boardman for both gas and diesel. So both of those tanks were removed, cleaned, demolished, and disposed of. DEQ was provided notification of the decommissioning and provided the decommissioning checklist and assessment report. Soil sampling was completed above, below, and beside the tanks, and no contamination was found. So those tanks performed well and did their job, and the site was returned to grade. So you can see in these pictures here, one of the tanks, I'm not sure if that's the 15,000 gallon diesel or the 10,000 gasoline tank. Here you can see kind of the excavation extent. I think one tank is still in there. It looks like one has been removed at that point. And then this is what the area looks like today. Stormwater from that fueling island, as well as kind of an equipment wash area, was diverted to a lined washwater pond. So in this picture, it might not look lined, but it is lined. Soil was placed over the liner to prevent animals from being trapped in there and to also protect the liner. So although it might not look lined, it was lined, and the soil above that liner was sampled and came back with some oil hydrocarbons. So we removed that soil for proper disposal, 291 tons. The soil below the liner was sampled and no contamination was found there. So this is a picture of that area being returned to grade as well. In addition to those kind of reclamation projects that have been undertaken around the site, also very important work of actually decommissioning the plant itself has been ongoing. And that includes, all these items you see here: draining the fluids and oil from equipment, cleaning and washing the plant, cleaning tanks, removing ash from systems, removing universal waste, radioactive sources such as exit signs, and removing those underground storage tanks. Has some of the details about the waste that's been removed to date. The hazardous waste is a little out of date. There's actually about 157,000 pounds that have been disposed of as of today. The largest sources of hazardous waste are sodium hydroxide, sulfuric acid, ammonia solution, and ethanol, which those four categories represent 94% of the total hazardous waste that's been disposed of. Non-hazardous waste, which is surfactant in water, there's 2,750 tons of non-hazardous waste, 152 mercury switches, about 54,000 gallons of oil, and 110,000 gallons of diesel fuel were disposed of. We had the 15,000 gallon diesel tank for the fuel island, but there's also a 400,000 gallon diesel tank near the entrance of Boardman that was used for startups that contributed a large portion of that diesel fuel for disposal. The plant equipment itself, we're trying to find other uses for. So initially we looked at our additional plants to see who else might be able to use some of those resources. After that, we looked to scrappers and vendors to purchase, and we've received about 1.7 million in funds from going to scrappers and selling off other pieces of equipment. And then anything that's left once we hand the site over to the demolition contractor will become kind of up to the demolition contractor to try to further get some value out of or dispose of. Okay, demolition, which is hopefully starting very soon. The ERM survey has been completed and all the asbestos and lead has been identified so the demo contractor can handle that all appropriately. We've made the plant cold, dark, and dry by performing all those decommissioning activities that we talked. The general high-level plan is to remove buildings and utilities to 2 feet below grade, abandon utilities deeper than 2 feet, and restore the site either by revegetation or covering with gravel, depending on the location around the site. We're currently in negotiations with contractors, and I might be a little bit out of the loop. We may have even signed with a contractor. It's any day now, and we plan on turning the site over to a contractor in October of 2021. And if that happens, I think what most people are interested about is what's going to happen to the stack. And so the stack and boiler would be imploded at the end of Q1 2022 if the contractor is handed the site over in October. This shows a high-level schedule that shows much of the work occurring in parallel. So notice to proceed very soon, mobilization, which includes preparation of plans and safety plans and that type of preparation for entering the site and being ready to start work will happen kind of throughout October. Turn the site over to the demolition contractor in late October, early November, and then they pretty much kind of hit the ground running and run a lot of their processes in parallel. So they'll be demoing, restoring, asbestos abatement, utility work, all of that will kind of be happening in parallel as they move through the site. And we hope for completion of demolition to be November, December of 2022, which is, I think, accelerated. I think previously we maybe have represented kind of late 2023. So everything will be demolished except those items either remaining for Carty Generating Station or potential future use of the site. This kind of plays into that useful language discussion. So fire station isn't PG property, but obviously that'll stay. There's a water tank, a little construction substation, and guard shack that will stay. This 400,000 gallon diesel tank will stay for future PGE use, not for Carty, but for if PGE wants to use the use as kind of a eastern laydown area or emergency management kind of area in the eastern side of the state. Parking lot will stay for future use development. The rail loop throughout the site will stay for future use. Intake structure staying for purposes of Carty Generating Station as well as that discharge channel, but everything else will be demolished, and this site will primarily be graveled over, whereas kind of anything outside of this area of the site will be revegetated. Okay, so this again is a timeline just kind of showing the work that has been occurring since we ceased operations. A lot of these items we already covered. I think most interesting on this slide is the costs that we presented back in October. I've provided some updates to those costs now that we've gotten through some of those items. So employee costs were pretty well known back in October. Those haven't changed. Our planning and management costs haven't changed. We've completed the coal yard reclamation, which is only a little bit more expensive than we thought. Ash disposal area came in a little bit under budget. Our decommissioning task came in a little over budget. These asset write-offs and long-term care haven't changed, but there was a big change in the abatement and demolition estimates based on getting the quotes back from all the various demolition contractors that we solicited quotes from. So that went from 34 million down to 15 million. And we'll see, keep you posted on any changes to that once we actually get into demolition. So the total cost of demolition at this point is 56.1 million is the estimate at this point. Okay, so in summary, demolition is a very dangerous task. So safety is critical and our primary success factor for this project. So far, decommissioning activities going on well, and there hasn't been any surprises. It's great that all of those liners and sampling and tanks performed well, and we didn't have any surprises in those soil samples. And really, in the next couple months, demolition work will start, and so we'll actually really start seeing some true significant changes in the appearance of the site over the next year. And then there'll be ongoing maintenance and requirements for the ash disposal area for 30 years under those CCR requirements. And with that, I'm actually going to go back to a slide because I forgot to cover some requirements of the site certificate. So I'm going to go back to the ash disposal area closure. In addition to those federal requirements that I discussed, there are site certificate requirements and those requirements in OAR 345-050 a little bit, which was covered in an earlier presentation. So the site certificate requires that we submit radiological readings to ODO for the site certificate, and then that we show that we meet certain exemptions in those state requirements. Samples were taken back in April of 2021 prior to the capping being undertaken, and indicated the material do meet the exemptions of 345-050. But honestly, our contractor failed to fully follow the sampling plan. So we are in the process of re-performing those sampling in accordance with the sampling plan, and plan on submitting that information to the department in the next month or so coming up here. So we've had meetings with the department and Max's group to cover those issues. But historic sampling and the sample results that we do already have, we don't anticipate any issues, but we just do need to make sure we follow that sampling plan that was provided to the department. And the soil that was taken prior to the cap being installed was still available for resampling. And then following that, we'll submit the request for termination of the site certificate because that will be the last site certificate requirement that still requires completion. Okay, with that, any questions? I can't see any hands, so if anyone has any questions, go ahead and.
Council members, does anyone have any questions?
Okay.
Well, I hear none, so I guess I'll say thank you for your time and sharing that information. It's good to know that the project to decommission is on track. Thank you.
Thank you.
Well, it is, let's see, 3:03. And does anyone have any further questions, comments, anything to raise? I see head shaking no, so I'm going to say the time is still 3:03 p.m. and the August 27th, 2021 meeting of the Energy Facility Siting Council is now adjourned. Thank you, everyone.
All right, thank you.
Thank you.
Thanks, everybody.
Thanks. See you next time.
Bye.